Ready to go. Ms. Nelson, I don't know that I have the add-on. When you say add-on, tell me what that is.
Judge, that is,
That's
George,
an add-on calendar, Judge. I think it's on your Outlook calendar, but I can email it to you if you need me to.
Let me see if I can find that.
this is the probation modification, Judge, I requested.
Okay, I've got it. Let me just print that.
And good morning.
Good morning. Okay, so the request is to handle positions 2 and 14 and the add-on first. So we'll do that. So let's see if I can. I don't know which screen is the city jail.
It says administrator, Your Honor.
Administrator, got it. There it is. Okay, everyone's waving. Okay, great. I've been asked to start with these folks first, so I think we'll start with Ms. Myers.
I think Ms. Rios may be talking to her still, or is she done? Okay.
Oh, she's right there. Ms. Rios, are you good to go to
Yes.
handle Ms. Myers' situation right now?
Yes, Your Honor.
All right, I'm gonna add you and if you, Ms. Hollander, want to come to the podium, add that. There, we've got everyone. Okay, good morning, Ms. Myers. Can you hear me?
Yes, good morning.
Good morning. I'm Judge McBurney. Your case has been assigned to me and you are on for plea and arraignment. So I think I looked at your case this morning, and Ms. Rios, you've already filed a waiver. Is that correct?
Yes, Your Honor. And I did file a motion for bond, but I talked to Ms. Hollander and we have a negotiated bond.
A negotiated bond, not plea, but bond.
Yes,
bond.
negotiated
bond.
consent bond.
Okay.
Sorry, terms.
Let me get into Odyssey so we can see things.
I just need that address to put on the form, Ms. Rios.
Okay, I will
Email?
yes, I will email it to you now.
All right, so I have Ms. Myers's case up and she has a bond, but I guess that's not working right now. So let me see what it looks like. It's a $17,500 good bond with no animals, and any animals you have are relinquished to someone. It doesn't say, but I'm sure we'll get more specific than that on our consent bond. So I'm going to start with the state because you'd need to be agreeing if I'm interested, if we're doing a bond less than what was set in January by Judge Treadwell. So tell me your thoughts.
All right, so we were going to reduce it to $4,000, $1,000 on each count. That forfeit surrender apparently only applied to the ferret. It did not transfer to the dog and the cat, so she is consenting to surrendering those two animals. I do have the cards from Animal Services this morning. I just need the address.
Okay.
Here.
Before we get into those specifics, there's 7 counts in the indictment. So the bond is going to need to cover all 7 counts. There were things added that weren't present when this was a complaint. So if the dollar amount is 4,000, I mean, you guys have a negotiated dollar amount. I'm happy to spread it across those counts, or sometimes Ms. Nelson simply just says total bond of 4,000 if that's the magic amount. But if you wanted 1,000 per count, then it's actually a $7,000 bond.
No, that the 4,000 is fine. She has no history of any harm to humans. And this does not appear to be an intentional cruelty. It was more of a negligent.
It sounded like neglect.
Yes.
From just reading the indictment. Okay, so a $4,000 bond, and again, Ms. Rios, I'll hear from you in a second. This is the state's perspective on this. And then it would be to relinquish all animals, not just a ferret, but a dog and a cat survived. There was a surviving cat.
A dog and a surviving cat. I have their cards here. We're not on the record, right? So I don't need to read out the numbers.
Correct, we're not on the record.
I'm just writing her address onto this card, and then I guess we were gonna need to ask for express permission for your honor to sign on her behalf, or do you want me to sign on her behalf?
On Ms. Myers's behalf? I'll ask her that in a minute.
Okay.
I'm interested in the conditions of bond, so it's relinquish all animals.
No custody, care, or control of any domesticated animal.
Okay,
No firearms. She must attend some type of alcohol class.
while on bond.
While on bond.
Okay, what is an alcohol, like going to an AA type thing, so a recovery class?
Yes. She will reside at the address that Ms. Rios will provide. And then she will surrender the 2 animals.
Well, I thought it was ferret, dog, cat, so I count
The
3.
ferret's already done.
That's been handled.
Yes.
Okay.
And that's it.
So residents, not a curfew, not an ankle monitor, you're not worried about flight. You are interested in treatment, and so that's the recovery meetings of some sort. Is there a frequency, 1 a week, 1 a?
I think it's just as recommended.
But who's doing the recommending?
Probably whatever class she signs up for.
Okay,
I'm not familiar enough, and we're not putting her on pretrial supervision.
okay, all right. And then the no firearms. Ms. Rios, anything you want to add to that?
No, Your Honor, that's what we discussed, and I've already relayed those conditions to Ms. Myers. I do,
Okay,
if the court, if you know that she does have 2 children that she needs to get back to, their ages are 9 and 11. And she'll be living with her husband.
is this a different address than the address where this situation arose?
Yes.
Okay.
So wait, Ms. Myers, did you want to say something?
Yes, ma'am. It won't be with my husband. We're separated. It would be with my children's father. We're not married.
Okay.
Okay, and that's fine. We just need to know what the address is. It needs to be not the address where this situation arose. So it will be with the father of your 2 children and your children, and no pets in the household. Ms. Rios, should this be a $4,000 bond, good bond, or through the sheriff's 10% program? So whoever puts up the money gets the money back. Do you have a preference?
I think the sheriff's 10% program would be the best since they can get the money back. But that still
Okay.
means she can go through a bonding company, correct?
Say that again?
That still means she can go through a bonding company though, correct?
Well, we indicate on the bond order which it is. It's either a good bond, and so Ms. Myers or family would post it through some private company and pay an amount that they don't get back, or it would be through the sheriff's 10% program where they post a certain amount, but they get all of that back minus a few processing fees. So,
Ms. Myers, would you prefer the sheriff's 10% program?
Sure.
Okay.
we'll
and
do
then-
that. If for some reason that doesn't work, Ms. Rios, just let me know and we can switch it. That's not a condition of bond where we got to track down the prosecutor and say, hey, do you care? The state was focused on a dollar amount and they're saying 4,000.
And Ms. Myers, the address you gave me, that is the address.
Yes, ma'am, the 1300 Collier Road.
That is not the, we'll talk because that is not
Okay.
the address you gave me.
Okay, Brian Cardenas has it as well.
Okay. I'll
When you say you two are going to talk, when is it you're going to, I mean, you're going to need to get the address to Ms. Nelson, whatever you think it is, Ms.
I'm gonna
Rios.
call her. That was not the address that was initially given. So I will get on the phone with Ms. Myers to get the correct address. So when you're done, if you could call me again to give me, because you never gave me that address.
Yes, ma'am, I'm sorry, I believe you have my previous address. I'm sorry.
Okay, and it needs to not be, this address in Oxford, Georgia, I'm assuming is not where, that wouldn't be jurisdiction for Fulton. Then there's a Stone Mountain address, also probably not our case.
Our address is the 3660 North Stratford.
Yes, I see that there. Okay, so that cannot be the address where Ms. Myers ends up. She's got a bunch of addresses. I hope whichever one we put down is one where we're going to be able to connect with Ms. Myers. Ms. Rios, do you have good contact information for some member of Ms. Myers' family?
Yes, I have several members of her families that I have their address and have spoken to.
Okay. Ms. Myers, I will sign this bond order once we get all that information. As soon as your family or friends can post the bond, then you'll get out. There'll be a scheduling order entered soon in your case. The state will provide discovery to your lawyer, and you and Ms. Rios will start talking about what you're going to do with the case. Do you have any questions?
Oh, no, sir, thank you.
Okay.
We have the surrender form.
Yeah, last thing. There are some forms, Ms. Myers, that need to be executed to complete the surrender. So the animals are in Fulton County custody right now?
Yes.
Okay. That if you were here in person, you would sign allowing those animals to be surrendered to the county. But we're doing a virtual calendar today. Do you authorize the prosecutor to sign those surrender forms on your behalf?
Yes, sir.
Okay. You're authorized. You should sign all two of them for the cat and the dog. And that process will unfold as it does. And Ms. Myers, your focus should be when you get out, obviously, to reconnect with your children and to stay in touch with Ms. Rios, okay?
Correct. Thank you, sir.
All right, Ms. Rios, anything else?
On that?
No, if you could just have her call me. Ms. Myers, can you call me so we can
Yes,
confirm
ma'am.
your address?
Yes, ma'am.
Okay. All right, that's it, Ms. Myers. We will turn now to Mr. 14, Mr. Rosser?
Oh, okay. May I be excused, Your Honor?
Yes, ma'am. Thanks for your help.
See you.
You will get whatever info. I guess the bond order doesn't need to have the information about those because that's happened.
Yes.
So if we need anything, we'll reach out. But I think it's just the address which we'll get from Ms. Rios.
Excellent. Yeah,
All
I just
right.
want to make sure that you know where to mail it.
Yeah.
Awesome. Thank you.
Bye. All right, Mr. Rosser, how are you doing today?
Pretty good. How about you?
I'm all right. You missed court, but we need to figure out who your lawyer is. Ms. Rios, would this be your case?
She's on the phone.
I'm sorry, who's this?
This is Mr. Rosser, position 14. He didn't show up for court one day.
Yes, he would be my case, so we can.
All right, then we're going to have a conversation about his situation. Let me pull up his case.
I had moved. Different.
And it's going to be my case, Judge.
And it's going to be Ms. Willingham's from the state side. All right. So we had plea and arraignment on September 2nd of last year. Mr. Rosser didn't show. So I signed a bench warrant and Mr. Rosser got arrested in connection with that or something else in the middle of February. And we're working through today what to do. You already did a waiver, Ms. Rios. So we'll get a scheduling order in place. Was there anything else you wanted to discuss today in connection with Mr. Rosser's case?
Yes, I filed a motion to set aside his bench warrant.
All right. And tell me why we should do that.
So he did not get notice. I know he moved and he believed he had updated his address. And he did not go notice in the mail, so that's why he missed court. But I think his father, I'm trying to make sure his father is on the call.
Okay. Let's look. There are lots of things on the call.
And this is number 14, Jorquez Rosser, right?
Correct. Position 14. Is there anyone on the Zoom call on behalf of Mr. Rosser? If so, you should unmute and let us know. Well, in the meantime, Mr. Rosser, one address I have for you is Hill Spire Drive in Douglasville. Is that you or is that your old address?
That's one of my mom's address.
Okay,
well, was one of my addresses.
Let me see. Let's find more. When you got arrested, which was 2 years ago in this case, the address you gave was Hill Spire in Douglasville. So that's why it was in the system. That's the address you gave everyone. And let me see if there was ever. You get your bond denied, then you got a bond, and then nothing happened for a while in the case. There was no address change. So my guess is the notices went to that address in Douglasville. What's a good address now?
Well, it was 1231 Princess Avenue.
You say was.
Yeah, it was, but we remodeling the house. I mean, you can still send a mail to that address though. It's like
well, I want the mail to go where you're going to be. If you get out, where are you going to be staying?
If I'm going to be staying, I'll probably move out with my mom at 8408 Hillspire Drive. Douglasville.
Back to Hillspire where we were sending the notices.
Correct.
Okay. Is there a reason you got your hand in your shirt like that?
Oh no, it's just no, I'm sorry about that.
I don't mind. I just want to make sure, like, if you were uncomfortable, we're going to address that. You can keep your hand right there. I'm just curious. So
I'll go back into his background. So my understanding is that he wasn't staying there, and so he didn't get the notices. So that's why if he had known that he had a court date, he would have come to court. He was working at the time he arrested. He has 3 children. 3 years old, 1 year old, and a 3-month-old. He was working at Taco Bell. He's currently in school.
and tell me what that means. Is he getting a GED or a college or a trade?
Technical, he's for cybersecurity, correct?
Correct.
Yeah. And for an LLC for also trying to do a medical career. So he was working, he was in school, and he's trying to take care of his 3 young children. So I'm asking for him to his bench warrant to be set aside so that he can continue to do those things. I have good contact information with him. I have his father's number. I have, I believe his mom's number too, and I will be updating him to make sure he knows he has court.
Okay, I'm just looking at the bond. So you're supposed to stay away from Chashawn Berrien? Who is that to you, Mr. Rosser?
Oh, that's the mother of my of my kids.
All 3 of your kids?
No, just 2.
Just 2. Okay. Well, the condition of your bond, one of the conditions of your bond is no contact with her. How had that been working before you got locked up?
I mean, it's been going good. So everything, I do everything through like my parents, you know, through like my mom or my dad.
Got it. Meaning your parents contact her or her parents when you want to see the kids?
I mean, correct. So I just legitimize my kids. So actually, my mom have the kids right now. You know what I'm saying? So
They're not with Ms. Berrien, they're with your mom.
Yeah, they're with my mom. They basically, yeah, me and my mom basically. Yeah.
Okay, so your mom and you are taking care of the kids?
I mean, yeah, of course.
Does Ms. Berrien get to see them?
Of course, yeah, yes, of course.
And how do you arrange that so that you aren't spending time with Ms. Berrien?
So my mom actually take the kids to her location, wherever they meet up at, every Sunday.
Okay, got it. So your mom is doing that communication.
Correct.
Okay. And whose house is this on Princeton Road?
Oh, Princess, that was my that was my grandmother's house, my great grandmother's house, like a family house.
And it's being remodeled.
Yes, it's being remodeled right now.
Where's your grandmother staying?
My grandmother, she's staying with like a family member. I don't know which specific family member, but I think she's staying with like my great auntie or something temporarily, or my uncle temporarily.
You'll be staying with your mom in Douglasville.
Correct.
Okay. Ms. Willingham, what are your thoughts about reinstating the bond and getting Mr. Rosser out to Douglasville?
Well, Judge, my first concern is that the address that he's saying he didn't receive notice at is actually still an address that he could have received notice at because he still has access to it.
Right.
And it sounds like he's always had access to it. So that would be my first concern as to that. And then I don't disagree as to where the children are, but I would disagree with that no contact provision being followed. We did not get an opportunity to get into depth of what the other altercations have been, but it is my understanding that there have been several other altercations since this incident occurred between the victim and the defendant. So I have some concerns, but I would still defer to the court as to how you would like to handle that, because it is my understanding that even the last incident, there still may have been, there may have been a bit of time now between that incident and their communication at this point. So I still think there's been a lapse of time at this point, but that order was not initially followed, would be the best way to represent it.
Okay, I want to make sure I follow you. The allegation in the indictment is that Mr. Rosser committed a family violence battery against Ms. Berrien in March of 2024.
Correct.
He eventually made bond and he's out. And you're saying since he's been out, you have reason to believe that he and Ms. Berrien have had other physical confrontations.
Yes, Judge.
Just not super recently.
Correct.
Because that's a almost 2-year period.
Correct.
So it hasn't been a peaceful 2 years, but the last few months, as far as you know, have been less problematic.
Yes.
Ms. Rios probably doesn't want you to talk about that, Mr. Rosser. And I'm not, this is not evidence, you're presumed innocent. I just need to make sure that you're going to show up, because you didn't show up for court the first time, and we were sending things to the very address you're going to go be at. So you're going to understand why I'm a little leery that, like, oh, well, now this address will be okay. And what if you decide you're not going to stay with your mom? We keep sending things to your mom, and somehow that doesn't get to you. So that's my concern. It's also a little tricky that you and Ms. Berrien have these kids together because she needs to see them. You get to see them. You've legitimated them. She's the mom. And it doesn't sound like you guys have really sorted everything out that you need to sort out. So it's complicated. Anything else you want to add, Ms. Rios?
Yes, Your Honor. I mean, I just want to say that I understand that the state is saying there's been interactions, but I mean, there's no charges filed. There's no new cases in regards to that. And I think too, before sometimes they don't know who to reach out, who their attorney is. And in this case, he knows who I am. He has my number. I have his family number, his family's numbers. And I'm not like guaranteeing that I'm going to make sure he's going to court, but I definitely would reach out when we have court dates. And I don't foresee there being a problem, given that I have 3 family contacts and his contact, and he has my contact information. I'm confident that he's going to appear for his future court dates. And he has 3 young children that right now his mom is doing the brunt of taking care of, and he needs to be out taking care of his kids because those are his responsibilities.
Okay. I think this would be a great situation for me to modify the bond to add a 6-month county-funded ankle monitor, because that'll help us figure out where Mr. Rosser is if he's not where he's supposed to be. And we can set up an exclusion zone because he needs to be staying away from Ms. Berrien, and we can make sure he stays away from that address. So what I'm going to do is, number 1, I have to confirm that his bond has not been surrendered. We run into these situations where a case is slightly older, and this one is, and unbeknownst to everyone, the bonding company surrendered the bond. And I say, great, I release you to the old bond, and there isn't a bond. And then Mr. Rosser is out with no bond at all, and that won't work. So I'm going to confirm that the bond was not surrendered. If it was not surrendered, I'm going to modify it to include the residence requirement that he stay at the address in Douglasville. Can't move from there unless you get approval from pretrial. So I'll add PTS. I'll add the electronic monitoring that the county pays for. And we'll add the address. So it's not a curfew. You don't have to stay home any particular time. You do have to stay away from Ms. Berrien. But this way, not only will Ms. Rios be pretty comfortable that you're going to show up, we'll be pretty comfortable that we can find you if you're not showing up for court. Ms. Willingham, anything else from the state?
No, Judge, I will confirm the victim's address though and make sure that I get that to you before close of business today.
Great, because we'll bake that into the bond conditions. That'll be the exclusion zone. Ms. Rios, any questions about what we talked about?
No, Your Honor, thank you.
All right, Mr. Rosser, did you follow what I said?
Yes, sir, I did.
Okay, so it probably won't be today that I set aside the bench warrant, but I will this week. And we just need to make sure that your bond wasn't surrendered. If your bond was surrendered, then you're going to have to post a new one. I won't make it a bigger bond. I'll make it the same bond. But I don't control what the bonding companies do. So we're going to figure that out and we'll go from there. Okay.
But I pay up to like $5,000. Like,
I bet you paid a whole lot of money. And when people use bonding companies, they sure hope that the bonding company doesn't surrender the bond, but you disappeared, as in we couldn't get you to come to court. And so I entered a warrant, and sometimes bonding companies then say, hey, now he's in custody. Look at that. Someone found him. So you don't need our bond anymore. And if they did surrender the bond, your family's going to want to talk to Jet Bonding about, wait a minute, the judge is saying reinstate the bond. We shouldn't have to give you $5,000 again. But that's a conversation for the business and the customer. I don't get in the middle of that one. Okay. And I'm not saying they did surrender it. I don't know how to look that up in the system. I just know that we've been burned before where it has happened. And then I release someone and they actually don't have a bond at all, in which case we don't have any way to make things happen. So I'll figure that out, and I'll let Ms. Rios know, and she'll let you know, okay?
Okay, thank you.
All right, see you.
Come on.
Judge McBurney.
Mr. Scheib.
Yes. Can I just make an announcement? I'm getting ready to do a hearing in Lamar County. They let me use their facilities down here to reach you.
Okay.
I just want to make an announcement on Mr. Weatherford. I spoke to the probation officer and indicated that we want an evidentiary hearing. And I understand today we're just been basically a consent situation. So respectfully, we'd like it moved to a calendar where we can have an evidentiary hearing on his probation matter.
All right, let me see. I don't have a warrant for him. I see your name on it and it does say revocation.
The petition.
Pardon me?
I sent you the petition this morning.
Okay. Let me, all I have is Mr. Reid's. You said something about Mr. Reid.
You should have Mr. Weatherford also.
I don't.
I will resend it.
Thanks. So the answer, Mr. Scheib, is of course, yes. Let me see if I can just get Mr. Weatherford 2 North Booth 3 on the screen as well. There he is.
And we were in touch with the family members, and he knows that I was going to ask for an evidentiary hearing on it, and it was going to be further noticed. And we're hoping, you could, whenever you can put it on your calendar, we'd appreciate it.
Yep, but it's helpful to know that because then the state will know it needs to get some witnesses. I just need to see the petition so I can know what the allegations are. Hey, Mr. Weatherford, can you hear us?
Yes, sir.
Have you been following what Mr. Scheib's been saying?
Yes, sir.
Okay, I just need you to hold on for one more second while I try to get someone to send me the warrant or petition in your case. And then what we will do, so you know what's coming, is we'll reset it to give the state an opportunity to get witnesses here or a witness. This will be in person, not virtual. Mr. Scheib will be in court with you, and it'll be a hearing where the state needs to prove up, if it can, whatever the alleged violations are. But I want to communicate them to you, and I want to see what they are because it'll give me a better sense of, ooh, that's going to take half a day, or that's a 30-minute one.
All right, thank you.
So just sit tight.
Judge, did you receive my email yet?
Nope.
It still didn't come through. Okay. Ms. Nelson, did you receive it?
No, I have not.
All right, I just got it. There was an issue with email. Now it's here. Okay. So the allegation, Mr. Weatherford, is that in late November of last year, you committed theft by taking, possession of a firearm, a couple things like that. So there was some incident on the 28th of November. You were being supervised out of Douglas County, but this incident supposedly happened in Fulton County. And what we'll do at a date to be announced is have a hearing on those allegations to see if the state can prove by a preponderance that those things happened. Mr. Scheib, anything else on behalf of Mr. Weatherford?
No, Your Honor.
All right, Mr. Weatherford, any questions?
No, Your Honor.
Okay, we'll get you into court along with your lawyer and Ms. Smith sometime soon to cover that. You're good to go.
All right, thank you.
Okay,
Thank you, Judge McBurney. You have a great day, sir. Thank you.
you too. Bye-bye.
Bye-bye. Okay, cool. 1 second. I'm checking.
Judge, I know we have one
No,
more
I
person from
appreciate it so much.
ACDC.
We're going to do that next.
After we do them, can we do Mr. James? I have to go to Judge Baxter.
Sure, if we can pull it up, but we're going to I just need a second. So Ms. Smith, when you see Weatherford on a calendar again, it's for the full-blown evidentiary hearing. So have whoever you need here.
Good morning, Ms. Pepper. How are you? Good. This is Smith from the ACDC. I'm as soon as I finish with this call, can I call like in 10:15 with the three ladies before you call Rush Street? Maybe I can go ahead and get them done before my 11 o'clock court. Okay, thank you. I'll call you back. Thank you. Bye-bye.
All right, oh, got that print out. Ms. Ford, can you hear us?
Yes, sir.
Good morning.
Good morning. How are you?
I'm okay. How are you? Ms. Ford, we needed to get you onto this call because I just needed to modify your probation a little bit because we were going to get you connected with some good programming. But I think the way I pronounced your sentence wasn't going to get you that programming. I'm going to ask Ms. Simpson to remind me what it is that we need to fix.
So we originally had her revocation hearing on March 3rd, excuse me, where she was revoked 5 months upon entering our ITF program.
Right.
And it was brought to my attention by our coordinator that that wasn't enough time for her to remain on the waiting list. And it was discovered that she had a release date, excuse me, to get out in like 2 more weeks. So we need to modify her revocation to revoke 9 months, retro dated to the original revocation date, and reinstate the balance, still with the condition upon her entering the ITF program.
Got it. So we're really the only thing we're changing is making sure that Ms. Ford remains eligible for the program by staying put. And once that bed opens up, she'll be able to start the program.
Yes, Judge. And I was informed that she will not lose her spot on the wait list.
Excellent. Okay. So Ms. Ford, that's what we're doing. I just want to make sure you understood that we didn't want you to lose your spot on the wait list. This is what we had talked about before. So I'll take care of what Ms. Simpson said we need to do, and we'll get you moving in that direction. Okay? Thank you.
Thank you, Judge.
All right.
Thank you. Bye, everybody.
All right. Thanks, Administrator. Take care.
You have a question?
Yes, Ms. Ford.
You're on it.
Okay, so it says that the release date for the ITF program was the 13th. So what happens?
So the release date was actually, that's when you would have been released. We did bad math, and the revocation I did didn't extend far enough out for the bed to be available for you. And so if I didn't change things, then on the 13th, you wouldn't go to ITF. You actually would have been released because your revocation would have been done. So I just need to extend that a little bit longer so that you are where you are now when that bed opens up at ITF.
How much and how much longer do I have to wait?
So I don't think they know for sure, but we've extended it a couple months so that we build in enough time so that the bed, when the bed opens up, you're still at ACDC rather than having been released and then we can't find you. Okay? But if too much time passes, I'll get you back either here in court or on a screen like this so that we can figure out a different plan. All right? Okay.
Thank you. Bye-bye.
Thanks. Take care. Which number?
Position number 10.
All right, that booth's not added. Mr. James, Javonta James. Booth 4, excellent. Thank you for raising your hand. 2 North, booth 4. Mr. James, can you hear me?
Yes, Your Honor.
Great, I can hear you. We've got who we need. Ms. Rios, I think you're handling this.
Yes, yes, Your Honor.
All right, so this is your arraignment date, Mr. James, and we're also going to talk about bond. I think you already filed a waiver. Is that correct, Ms. Rios?
Yes, Your Honor.
All right, so we've got a waiver. We'll do the scheduling order, and that means we should talk about bond. So let's get on the record for that. Do we have Ms. Rivers? We do. Good morning, Ms. Rivers.
Good morning. How are you?
I'm well. Yourself?
I'm doing good.
Good. All right. So let's get on the record in 26 SC 000-496. It's State versus James. Mr. James is at Rice Street. Ms. Rios represents Mr. James. She's virtual, and Ms. Willingham is here in the courtroom for the state. Mr. James, your lawyer, Ms. Rios, filed a motion for bond, asking that a bond be set, which says to me you have no bond at all, but regardless, she's going to tell me what your bond should look like. I'm going to hear from the prosecutor as well, and then I'll let you know if I am going to set a bond, and if so, what that bond looks like. Ms. Rios?
Yes, Your Honor. Mr. James is 20 years old. Before being arrested, he was working at Wendy's. He has one child who's 1 year old, and he has another child on the way. He lives with his dad. I'm acting for a $5,000 bond. I don't believe he has an extensive history or much of history at all. And this is a case I believe we were trying to work out, but I just need more information before, but I don't believe this will be a time offer case.
All right. And where is it that Mr. James, I don't need the street address, but into what setting would he go if he's released?
He lives with his father.
Lives with dad. Mr. James, who else besides your dad lives at whatever address you'd be going to?
It's just my father.
So just be the two of you?
Yes, sir.
Okay. Now you have a young child, boy or girl?
Girl.
And where does she stay?
With her mother.
Okay. You also have these charges, and the alleged victim is Janiyah Terry. Is that the mother of your child?
Yes, Your Honor.
Okay. So if you get a bond, you're not going to be able to be around Ms. Terry, which probably means you're not going to be able to spend a whole lot of time with your child unless there's some adult who is able to get the child from Ms. Terry and get the child to you. Do you understand that?
Yes, Your Honor.
Okay. Ms. Rios said you also are expecting a second child soon. Is Ms. Terry the expectant mother, or is it someone else?
It's Miss Terry.
Okay. Same situation. She probably wants all sorts of support right now, but until we resolve these charges, unless the prosecutor tells me something different, you are not going to be able to be around Miss Terry to help her through what she's going through right now. You understand that?
Your Honor.
Okay. Let me check one more thing. The address that I've got in the system for you is an apartment on Fairburn Road. Is that where your father lives?
No, Your Honor, that's my mother.
Okay, so that's not where you would be going.
No, sir.
Okay. Ms. Rios, you'd be able to get Mr. James's father's address to Ms. Nelson?
Yes, I'm trying to text with his father right now because I believe Mr. James didn't give that to me when we last met, but hopefully I can get that from him.
Okay. All right. We do have pretrial on the call. Good morning, pretrial.
Morning, Your Honor.
How are you, Ms. Hardy?
Wonderful.
Great. Can you share with me whatever criminal history information you have on Mr. James?
Is that position number 10?
Yes, ma'am.
Okay, there are 2 arrest cycles, no felony convictions, but there is an open case for battery family violence under 26 CR 000452D. Nothing further.
Okay. Thank you. Appreciate it. That's not this case.
No, but it is the same victim and it happened only a few months apart. So our incident happened in March of 2025 and the other incident that is still with state court happened in August of 2025 and it is the same victim. So as Your Honor can expect, the state would be objecting. He was arrested for both cases at the same time.
Okay, because
So he's in custody for both at the same time. But when he was arrested, there was a warrant taken out for each, the March and the August incident. And then he was ultimately picked up in January for both cases.
Okay.
So the state would have some concerns about the risk to reoffend,
Sure.
the risk to intimidate the victim in this case. I do believe Miss Terry may be on the call. I know she got the Zoom link from me this morning, and I know that she does not agree with me leaving or wanting the defendant to stay in custody. But as Your Honor knows, that's kind of the nature of the charges that I deal with, as it is a domestic violence case. In our incident, she did have actual visible bruising, which again, as Your Honor knows, that's not always something that officers are able to see, which tells me the escalation of this. And then to turn around and do something very similar only a few short months later, I would have some serious concerns about the defendant being released at this time. So the state would be objecting to that. But I obviously, as pretrial has stated, I recognize that outside of these cases, there are no other charges, or there's no other criminal history, but I have some serious concerns.
Sure. There's just a lot going on between Mr. James and Ms. Terry.
Yes.
Do you know if there's a bond in the state court case?
I have it open 1 second, Your Honor. I believe there is. Yes, there is a $2,000 bond in the state court case.
Okay. And that incident happened more recently than the one that we have.
That is correct.
Okay. Do you have a good address for Ms. Terry?
I can confirm it. We were texting this morning.
Okay.
So
Got it. You don't need to share it with me right now, but I am inclined to do something similar for Mr. James, which would be a county-funded ankle monitor and a stay away from Ms. Terry's address and handle it that way.
Yes, Judge.
Okay. Ms. Rios, was there more that you wanted to add?
No, Your Honor. It sounds like he will be likely getting a bond with the ankle monitor. And I would just say that, like, yeah, since he's not like he violated any no contact provision, in these cases happen close to each other. And so with the stay away, I think that would be enough. So no further incidents would occur.
Mr. James, are you able to go back to the Wendy's job? Do you know, or is that gone?
That's gone. I got,
Okay.
I'm applying for a Amazon job when I get out.
Okay. Does your father work?
Yes, sir.
What does he do?
He works at a warehouse.
Okay. Does Ms. Terry have support to help her take care of your kids?
Just her grandma.
Okay. Were you providing financial support over? Okay. if you get out on bond, you should still provide financial support. Who is a safe go-between so that you and Ms. Terry aren't having to talk or interact?
Her grandmother.
Her grandmother? Okay. All right. Okay, so Ms. Nelson needs from you, Ms. Rios, the address of Dad's house, and from you, Ms. Willingham, the address of Ms. Terry. It doesn't sound like that's confidential, so we can put it in the bond order so that Second Chance knows that's the exclusion zone, 100 yards from Ms. Terry's house.
Yes, Judge, I'm working to get both of those, so I will get those sent over to Ms. Nelson shortly.
Okay, well, Ms. Rios, are you going to get Dad's address?
Oh, no, I'm sorry. I was
Okay.
referring to the other case.
Okay, got it. All right, anything else, Ms. Rios, on behalf of Mr. James?
No, Your Honor, did you say what the bond amount was gonna be?
I'm going to set the bond at $10,000 through the sheriff's 10% program with the ankle monitor, the electronic monitoring, county funded. There will be pretrial supervision, no contact with Ms. Terry in any way, shape, or form, other than indirect contact through the grandmother. That is someone that Mr. James could contact to say, hey, what's the best way to get diapers to Ms. Terry? What's the best way for me to see my kid? That kind of thing. And Mr. James will need to reside at his father's. We just need to get that address. Okay?
Thank you, Your Honor.
You're welcome. Mr. James, any questions about any of that?
No, Your Honor.
Okay. If you do make bond when you get out, make sure you establish contact with Ms. Rios, and we need to update your address in the system. So Ms. Rios, you should do that because notices are going to go to this apartment on Fairburn Road.
Yes, Your Honor.
Okay. All right. Ms. Willingham, I think we've taken care of your business for you.
Yes, Judge.
To go? Yes, ma'am. And we will, hold on, see. We'll see you next time.
Tomorrow.
Okay, that'll work. So now, Sheriff's team, I'm just going to go down the calendar as it's published unless you need me to do booths in a different order. And Mr. James, you're free to go. You don't need to stay in that booth anymore unless you've got a question.
No, sir.
Okay. Hi. Good morning.
I'm here for Mr. Estabbon Orlando. Position group judge.
Your Honor.
Yes.
Hey, good morning. So I do not see Mr. Estabbon on the call. He's the client. He's one of my clients is housed in Floyd County. And I spoke to Floyd County on Monday and they're not as excited about helping us set up contacts. But I'm going to work through it. But I did just want to let you know, I don't see him. So I have a feeling we might have to reset that one.
Okay, I will work with Ms. Nelson and our friends with the sheriff's office to see, to get a report very quickly. So I've asked you to stay a little bit longer so we can get word on, is it Mr. Estabbon or Mr. Ovando? Estabbon I thought would be a first name, but yeah. But either way, Ms. Wood and Ms. Rios, you should both know this. I have engaged with Colonel Edwards to flag Floyd County as one, being very far away, but two, we've experienced what you did, which is they're not Zoom friendly. Right. And so judges have been ordering people up to come down here for a 5-minute status conference. Right. It's a 3-hour round trip for a 5-minute appearance. So we're working on maybe Floyd County houses pre-indictment cases, or maybe they figure out how to get someone in front of a screen.
Judge, I'm sorry to interrupt. The jail was working on that today. You might want to ask Ms. Reynolds if they have an update.
Okay. Good morning, Ms. Reynolds. She may be
hear me now?
Yes, ma'am. Good morning.
Okay, good morning. So everything you just said was absolutely correct. So we are going to go back to my supervisor and see what's the status, because as of now, we do not have him. So I don't want to give you an answer right now.
Okay.
But I will speak to my supervisor so we can see what direction we're going in.
Great. If I'm going to call him Mr. Estabbon just because that's how it's listed on the calendar. But if Mr. Estabbon is not already en route, please do not get him on a van. He should stay where he is, and we'll just do this the complicated way and have him come to court soon, so Ms. Wood can get his case moving. But if he is en route, then if you could just give us an ETA, that would be fantastic.
Okay, great. Let me go ahead and speak to my supervisor, and I will let you know in about 2 minutes.
Okay, thank you.
Thank you.
Madam Interpreter, tell me, are you with us full time? Meaning if you leave here, you're just going to another courtroom, or were you here specifically for this case and we've been paying a lot of money to have you?
I'm here for all day.
Okay. Are there other courtrooms you need to be going to, or an office you want to go back to? Because I'm happy to give you a call or shoot you an email once we get an update on Senor Estabbon.
There is a 10 a.m. arraignment in Judge Dunaway.
Okay. Why don't you go there?
Okay.
And then poke your head back in here when you're done with that. That would be great, and I'll let you know what we heard.
Are you supposed to sign every time I come in, or I'm not sure how it works?
Usually I sign at the end and you will have said, hey, I was in McBurney's courtroom for a grand total of. That said, I'm happy to sign every time. If it's easier for you to keep track of individual visits.
Maybe because it might be our other interpreter, the two of us.
Great, then let's sign for this one.
Thank you.
You're welcome. Mhm. All right, so we'll see you soon.
Yes, sir.
Thanks.
Thank you so much. I suppose if he appears before.
We'll sit tight.
That if you could.
We'll send a red alert. If he suddenly appears, then we'll say all hands on deck as soon as someone could get here.
Yes, sir.
Thanks.
Thank you.
You bet. Good morning. Are you Mr. Chad Johnson?
No, I can go get them for you though.
Nope. Stay right there. Tell me who you are.
I'm Carlos Thompson.
Say your name again.
at the
Oh,
very-
Carlos Thompson, number 15. Gotcha. Okay. Oh, I don't recognize that lawyer.
He's with our office, Judge. Mr. Thompson will be mine.
Excellent. There's Ms. Wood. All right, Carlos Thompson. I'm Judge McBurney, and you are in a similar position as Mr. Rosser. Let me pull your case up so we can figure out what's going on, and then I'll hear from Ms. Wood.
Judge 88 Williams is the assigned prosecutor in this case. I am reaching out to give an update.
Okay.
She thought it was.
Okay. Oh, your bond got revoked, not just you missed court, a judge revoked your bond. Ms. Wood, we don't have the lead prosecutor on this case. We do have Ms. Smith. The bond was revoked. It wasn't just that there was a bench warrant. So it's a little bit different situation than Mr. Rosser. Need to recalibrate. It doesn't, let me see where else we were with The bond was revoked. I don't think we've had an arraignment because maybe Mr. Thompson didn't show up for plea and arraignment. So why don't you tell me what you think we're doing and where we are with the process? And then if we need to get substantive, we got to figure out if we can get Ms. Williams here.
Judge, so just a heads up. So this one, I'm very confused because it looks like he missed court last fall, but then his bond was revoked at one of those compliance hearings by Judge Manning last month, literally a month ago.
Yep.
I did reach out to Ms. Williams. I am planning to see Mr. Thompson actually this afternoon at the jail. So if we could just do an arraignment today, and then I hope to have like a better update for the court after I speak with Ms. Williams, because there's a couple of things about the case that I don't think we'd be able to do anything substantive today.
Got it. Okay. Mr. Thompson, I will hear from you. I saw you raised your hand. But based on what Ms. Wood is telling me, I think we're going to table for today what was going on? You missed court, and then you didn't miss court at some point because you got your bond revoked and you're in custody now. We need to get to the bottom of that. But more importantly, Ms. Wood wants to meet with you directly and learn more about your situation. And she's got some questions about these allegations that she wants to press the prosecutor with. So I think what we'll do is Ms. Wood is waiving your arraignment, meaning she's going to enter a plea of not guilty for you. She's going to fill out some paperwork. That'll get the case moving along, regardless of what's going on with bond. We want the case to be moving along. Because we want to figure out what's going to happen with the case. And then we'll get you back here in short order to figure out these other things. But you've raised your hand. Tell me what your question is, but before you ask it, just don't talk about the substance of your charges, okay?
No, I'm not talking about any charges. I was just trying to let you know that about why I missed court. That's what I thought I was here for.
Okay. Well, I sort of thought you were too, but the fact that you missed court, in some ways isn't the issue right now because another judge revoked your bond. And so you and Ms. Wood need to talk first because she would need to not just say, set aside that warrant, but Judge, you should give Mr. Thompson a bond. And we have to talk about what that bond looks like, et cetera. That requires the other prosecutor to be here. And more important, Ms. Wood wants to talk to you more about the case so that if she's going to be pushing for bond, she's got all the information she should have. And that means she needs to meet with you, which is exactly what said she was going to do. So save those thoughts about why you missed court. I'm very open to hearing about it. I understand that sometimes the gap of time between when an incident supposedly happened and when finally you're indicted can mean people have moved and stuff's happened. So there's lots that happens, and I need to give Ms. Wood a chance to connect with you. I don't think that's what happened here because you were originally arrested on this case in September and you got indicted less than a month after you got arrested. So things were moving fast, and you missing court probably will need a better explanation than, hey, a lot of time passed between my arrest and when I was supposed to be in court. But I want to give Ms. Wood a chance to meet with you to talk about that, okay?
Thank you.
You bet. Ms. Wood, anything else on behalf of Mr. Thompson?
No, Judge, thank you.
All right, so you'll do that waiver, and then you'll let Ms. Nelson know when we should get Mr. Thompson back here to talk about bond, warrant set aside, et cetera. Are you here from Mr. Thompson? Okay, hey, so you know your mom is in court.
Yeah, I know.
All right, I don't know how you know because you couldn't see her, but she says hi.
We talked earlier this morning.
Okay, you want to say hi to mom?
All right, bye, Mama. I'll call you later.
He's going to call you later. Thanks for being here. All right. Okay, so Mr. Thompson, I will see you soon, probably in person, to talk about this bond situation, okay?
Thank you. I'll see you soon then.
All right. Thanks, Ms. Wood. Can you get, since you guys are sharing a booth, can you get Chad Johnson to come on in?
Gotcha.
Appreciate it.
Chad, good.
Spunky little guy. Will you let Ms. Williams know she don't need to rush down here now? Thanks.
Hello.
Hey, are you Chad Johnson?
Yes, sir.
All right. Ms. Rios, let's get you on the screen. Oops. There you are. Mr. Johnson, I'm Judge McBurney. Your case has been assigned to my division. Ms. Rios is the lawyer representing you in connection with your charges. And today is your arraignment day. Ms. Rios, I have not checked the docket. Did you already file a waiver? Are you planning on filing a waiver? Have you worked this case out?
Filed a waiver.
Okay. Is that all we're doing, or have you and Ms. Smith talked about the case, or what's happening?
We have not talked about the case. I believe I also filed a bond motion, but let me double check. Yes, I did file a motion to reduce his bond.
Okay.
Right now, his bond is $11,000. I was hoping we can reduce it to $4,000.
Ms. Smith, it is in the docket. It's been in for about a month. It doesn't say so on the calendar, but given these charges, are you okay talking about bond?
Yes, I know about it.
Oh, you knew about it. Great. Excellent. Now I know about it too. So why don't we get on the record then in connection with Mr. Johnson's case. This is 26 SC 000299. Mr. Johnson is charged with second-degree burglary and obstruction of law enforcement. He has a bond now that was set in January, the day he had his first appearance. $11,000 good bond for these same charges, so that's good. And he was supposed to stay away from where this burglary supposedly happened. That's pretty much it. So Ms. Rios, tell me about Mr. Johnson, why you think his bond should be lowered.
Yes, he's 32 years old. He does not have any children. He was last working as a server. He cannot afford this bond. He does not have any funds. I have got him in touch with my social worker, and we are looking for a program. And if he's accepted to one, then we can try to get his bond paid through a bail project, and they usually only go up to $5,000.
Got it. So your goal of getting it reduced would be if you can get some structured programming, bail project will swoop in, they'll fund it, he'll be in that programming while we wait to see what happens with the case.
Yes, Your Honor.
Okay. Ms. Hardy, can I have criminal history information, please, on Mr. Johnson?
Yes, Your Honor. There are 9 arrest cycles, arrests out of Georgia, Alabama, Illinois. No felony convictions. There appears to be a hold out of LaGrange for a probation violation. The date of that is April 22nd, 2025. And then one out of Asheville, Alabama for an FTA. April 23rd, 2025 is the date of that warrant. Nothing further to report.
Okay. Thank you for that. Ms. Simpson, do you have anything in your system about probation wanting to see Mr. Johnson?
Yes, Judge, he does have a Troup County probation warrant. In addition to, there is a notation in our system that Alabama did also issue a warrant for absconding. I just want to also add that he has requested to his officer that he wanted to complete an ICOTS to Alabama. So I'm not exactly sure if his residence is here in the state.
Got it. Okay. Well, given those warrants, I don't want to do anything with the bond. I think keeping Mr. Johnson here so we can sort this case out and figure out, hey, is there actually some programming, drug court or Georgia Works or who knows what, that he would benefit from, makes a ton of sense. And he does need to make his way down to Troup County, or we would need to resolve it here if Troup County wanted to somehow send it to us. I can't do anything with the Alabama piece. But Mr. Johnson, you are a popular guy and are wanted in some places pretty far from here. We're going to sort out your business here before I send you off to troop or off to Alabama. Do you have family in Alabama?
I have no family in Alabama. I just live here in Georgia.
Okay. So you just had been in Alabama and managed to pick up a little trouble in Alabama.
Yes, coming from Alabama back to Georgia.
Okay. Got it. Okay. Well, we're going to sort out your Fulton stuff, and then you can pivot and probably get down to troop after that. Ms. Rios, anything else in connection with Mr. Johnson?
No, Your Honor, thank you.
Okay. Ms. Smith, I didn't really ask you at all, but now you know what's happening. Anything you want to add?
No problem.
Okay. Mr. Johnson, Ms. Rios is going to get the discovery in the case. She will get that to you and talk to you about it. And you guys will figure out, is this one that we want to file motions and get to trial soon, or is it one to work out? And I will see you once you and Ms. Rios have come up with that plan, okay?
Okay, when do I talk to Ms. Rios?
I will come talk to you soon. I'll come to the jail.
All right, thank you guys so much. Thank you.
All right. You're good to go. Thank you.
Your Honor, that concludes my business. May I be excused?
You sure? You don't have any of the other cases on here?
I am almost positive.
Let me just look at the case numbers. So if we lose you, they're all low numbers. Mr. McDow has a lot of cases. This is 0, there's 1. Okay. All right. Sure. You have a great rest of your day.
Thank you. I'm still sick from yesterday, so hopefully I feel better tomorrow. And
Well, it's really nice in here now. It's balmy. It sort of feels like we're in the tropics. You asked me to turn up the temp, so I did, and you don't even show up.
Well, that's damage already done. You see this tissue?
That's terrible. I'm not going to be able to sleep well tonight because of that. I'm sorry. We'll work on it.
Thank you.
All right. Bye-bye.
Okay, Your Honor, so I just got an update.
Yes, ma'am.
He is not en route. We are trying to figure out, or they're going to communicate about a way to get them here on time, but he's not en route.
Got it. Okay. Well, then he should stay there. We will reschedule him, and I'll probably have another chat with Colonel Edwards about how Floyd County is working and not working. But I very appreciate you checking in on that one.
All right, thank you. Sorry for the inconvenience, but
No. It's not you. I appreciate the update. It's helpful info.
All right, thanks.
Bye. Ms. Wood, we will set Mr. Estabbon down on an in-person calendar.
Thank you, Judge.
You bet. To South Booth 3. Mr. Woods, can you raise your hand? Yes. All right. I'm going to get your speaker on.
Judge.
Yes, Ms. Wood.
Just to give you my camera has stopped working on my laptop, and then my phone is not connecting to my office internet. So just give me 30 seconds. I'm going to pivot over to my phone so Mr. Woods and Mr. McDowell can see me. But I just want to let you know it's going to be waivers on both of them.
Okay.
So I'll be right back.
Great. Mr. Woods, we're going to start in 1 second. But your lawyer, Ms. Wood, wants to be seen and see you, etc. She's having technical difficulties in her office. So she's going to pop back on, and then we'll have a brief conversation about your case.
That's fine, y'all.
Thanks for your patience. Oh, she's back on. Look at that. Let's add spotlight. There she is. That was quick, Ms. Wood. All right, so this is Bryant Woods. Mr. Woods, you're charged with burglary in the 2nd degree, a couple other charges. And it sounds like what we're going to do today is Ms. Wood, and she may have already filed it, but she's waiving arraignment. meaning she's entering a plea of not guilty for you. That will prompt the state to get all the discovery it has to your lawyer so she can meet with you and talk about the ins and outs of the case, the strengths and the weaknesses, things like that. And then you guys will figure out how you want to move forward. Does that make sense?
No,
It does not make sense. Tell me what you're not sure about.
I had already wanted to waive the case.
When you say waive the case,
Yes,
meaning you wanted to plead guilty or you wanted the case to go away?
yeah, I wanted the case to go away.
Why do you think it is? I mean, it would be great if every defendant had that superpower, but you don't. And so you may want it to go away, but the state is standing in your way, and they brought these charges. And so it's going to go away in one of three ways. The state could dismiss. I don't see Ms. Smith saying she's dismissing right now. You could go to trial. That's not going to happen right away. Or at some point, and today may not be that day, you may decide that you want to enter a plea and move it forward that way. But it's state dismisses, not you, and not me. I can't just make it go away. So state dismisses, you go to trial, or you enter a plea. And what Ms. Wood was telling me is today's not trial, obviously, but it's also not a plea. She wants to see what the evidence the state has and talk with you about that. So maybe I should ask the question differently. Not do you like that situation, but do you understand that's how things are flowing along?
I do.
Okay. Do you have questions about anything we've been discussing?
It's just taking a while.
It has not moved quickly.
Good.
That is not Ms. Wood. Go ahead, Ms. Wood.
So he has an unindicted case. Miss Ross has been working with him, so I'm hoping to have a resolution for him very soon. I just need that last piece from Miss Ross before I can present it to Miss Smith.
Got it. So, Mr. Woods, this is often the situation. A defendant has multiple moving parts. The only case that's in front of me right now that I could do something with is the indicted one. But apparently you've got another set of charges, maybe the same kind of thing, burglary in the second degree, who knows? And Ms. Wood wants to get that wrapped into the case we've got so you can take care of your business in one fell swoop. Rather than, and I'm making this up, but rather than in this one, you plead, it's time served, but you can't get out because you've got these other charges, and then you're waiting even more time to get in front of a different judge to talk about that other case. Why not talk about everything with the same lawyers and the same judge? That is an efficient way to handle it. But it's also a reason why you may be feeling like, gosh, this is taking longer than I would think, because the state's got to do something with that other set of charges. Was it a surprise to you to learn that you've got other charges?
Yes, it is.
Do you have a PI number, Ms. Wood?
Yes, Judge, it's 25 PI 008396.
Okay.
That number somehow rings a bell?
How many charges I have in all? Is it like 4?
So let me tell you what's going on, Mr. Woods. The case that you've got with me is an indictment or an accusation for a burglary in the second degree, possession of tools for a crime. The allegation there would be like you broke into a storage unit or a store or something. I'm not saying you did, but that's the allegation. This other case is a theft by receiving stolen property. So that's different. That would be you were driving a car that wasn't your car. I don't know that it's a car. I don't have the document in front of me, but that's a different set of charges, but they're not indicted yet. And so you need to handle both of them. And Ms. Wood is trying to grab that theft by receiving stolen property charge and say, can we bundle it in with this other stuff and resolve everything?
Okay, I understand.
Okay, now you understand. Good. So Ms. Wood is waiving arraignment for you. That just means she's entering a plea of not guilty. That gets the charged case moving forward quickly. She's going to be talking with the prosecutor about, hey, could we grab that other charge and work that one out as well? And once that's happened, we'll get you here in court, not virtually, and we'll take care of all that business. Okay? All right. Ms. Wood, anything else on behalf of Mr. Woods?
No, Judge. I will see you soon, Mr. Woods.
Okay, thank you.
All right. Take care, Mr. Woods.
So,
Now, Mr. McDowell, 4 South Boot North. Hey, Mr. McDowell, can you hear us?
Yes, sir.
Great. I'm Judge McBurney. Good morning.
Good morning.
Whew, Mr. McDowell, you have three new cases and a revocation on another case. That other case is in non-complex, but I guess we're handling the revocation, which is why it came here. But Ms. Wood already previewed, I think, what we're doing with your situation, which is she is going to waive arraignment for you in your new cases so she can start to get discovery in all those cases and meet with you to talk about, hey, is there a way to wrap all this stuff up into one big resolution? Ms. Wood, what do you want to add to that?
Nothing, Judge. I will be out to see you soon, Mr. McDowell, but yes, I will get waivers filed today.
So, Mr. McDowell, the waiver is just an entry of a plea of not guilty. And as you've heard me tell other people now, that'll trigger the state's responsibility to hand over discovery, whether it's body cam footage or surveillance footage or whatever, all the paperwork they've got. That way you and Ms. Wood can start figuring out if the state's case is good, bad, ugly, whatever you might conclude from reviewing that evidence. And then we'll get back together to figure out what you're going to do. Do you have any questions about where we are in the process now?
Yeah, I just want to know how many cases I have.
So 3. There's one that charges you with obstruction of officers and interference with government property. That's often you allegedly broke something that belonged to the police. One of them is burglary in the 2nd degree. And then one of them is a whole bunch of burglary in the 2nd degree. Looks like 7 of them. So 2 burglary cases, 1 you had a dust up with the police case, and then you've got your revocation. You took a plea a couple years ago, and you're on probation, and you picked up these new charges. Okay? Oh, is there more?
I see.
Hold on 1 second, Mr. McDowell.
Oh, down there, I do see 3 GI cases.
Yeah, I just wasn't sure if those were these cases.
They're not.
So there's 3 more out there.
Yes.
So, correction, there are 3 cases that have been indicted, but you've got 3 unindicted cases as well. They may turn into 1 indictment. They may, sometimes the charges are related. 2 of your PI numbers are consecutive numbers. So those are sometimes, they turn into 1 indictment. But basically, Mr. McDowell, you've created a big homework project for Ms. Wood because she needs to learn about those and then engage with the prosecutor to say, can we put all this in one big basket that says Akeem McDowell on it and try to work them out? I want to manage your expectations. That does not happen in 30 seconds. Your productivity with these cases means Ms. Wood has to do a bunch of research to figure out what are the charges and are there cases where we should say, you need to dismiss those, we'll plead to these, not those. And maybe you want to go to trial. I don't mean to suggest you have to plead to anything. But you have been busy on the wrong side of the law recently. And that means you're going to be, it's going to take a little bit to work through all this, okay? Did that answer your question?
What about
Say that again?
What about just one plea?
If you just want to work it all out, there's a good conversation for you and Ms. Wood to talk about. But one thing I bet she's going to tell you, and I do not speak for her, is, hey, Mr. McDowell, don't just plead to the cases that are indicted. Let me get these other cases charged so that you don't plead to these. And just when you think you're done and heading out, they grab you and say, wait, what about the unindicted cases? I think she's going to encourage you to, if you're going to plead to things, to also handle the charges that haven't been indicted yet. But there's a way to make that move fairly quickly. Ms. Wood just needs to look at it and then talk to you about it, okay?
Yes, my people say I also have a hole in Cobb County. I'm trying to see if they're gonna bring the case to court or.
Your holding Cobb, is it for also open charges or is it probation?
No, they ain't giving no information. They said I got a hole.
Okay. Ms. Wood, do you know anything about Cobb?
I do see the hold on the screen, so I will look into that and see what I can find out for him.
Judge, that's not a probation hold.
Okay.
He does have a probation hold for Douglas and Paulding County.
Mr. McDowell, my gosh. He's done. All right. He'll see you soon. Okay.
Man,
oh, he came back.
He's so crazy, man. Yeah, I appreciate y'all. I'll talk to you before.
Okay. We appreciate you too, Mr. McDowell. Take care. All right. Well, good luck with all of that. Ms. Wood. It's like they should have a little passport. Like sometimes when you go to a kid's museum and you get a stamp each place, you could get Douglas and this and that, and he'd have a full passport. All right. I don't know exactly why the revocation got put on the calendar. It's a non-complex case. I'm happy to deal with it when we deal with Mr. McDowell's many cases. I don't know that it will appear published on there again, but we certainly can resolve that when we resolve everything else.
Got it. Thank you.
You bet. All right. We should have at least 2 more people. So let's find them. 3 South, booth 2.
Anna, could you open up 3 South booth 3?
Yes. Yeah.
He may be sitting and be occupied.
Yeah.
So he may be on 3 South booth 3.
I'll do that because booth 2 looks full and yellow. 3 South, booth 3. Didn't like it. Let's try one more time. So I added booth 4. I can't open booth 3. Zoom wouldn't open it up. So is there a way, Ms. Reynolds, to see if we could get Mr. Shorten to slide down to booth 4 on 3 South?
Give me 1 second so I can call the floor.
Okay, thanks.
Gosh, I'm sorry. Are we talking about position number 9?
Yes.
Okay, I didn't know if he was. Is he in a booth? I think I had sent an email about him.
Yeah, he was transferred to another court.
Yeah, he's
Yeah.
on the competency docket.
Correct.
Oh, he is not with us anymore. Okay.
Correct.
Competency docket. All right. So Ms. Reynolds, don't worry about position 9.
Cool beans, thank you.
You bet. Good morning, 4 South, booth 3. Is this Mr. Reid?
Yes.
Hey, Mr. Reid, how you doing?
All right. Kind of all right.
Kind of all right. Well, we're going to talk a little bit more about your situation. You are on the calendar for a probation revocation. You've got 2 cases for which you are on probation, and I signed probation warrants for you. I'm going to get all this on the record in a minute, but let me find out. Ms. Wood, are you handling things for Mr. Reid?
Judge, so I think this is Ms. Rios's client, but if you can just give me a minute, I'm gonna ask her. I'm happy to handle it. Because I do see where she's been visiting him at the jail.
Okay.
So if I could just have a minute, I'm gonna text her and I'm happy to handle it if she wants me to do that.
Great. Please check.
Your Honor, I haven't been in any trouble.
Okay, well, let's not get into that. The allegation is just that probation couldn't find you, not that you got in trouble. So that's a manageable thing, but let's wait till we get the right lawyer on the screen for you, okay? Mr. Reid, I'm looking at your cases and Mr. Jerome filed something on your behalf. Does he represent you?
Mr. Jerome was my first probation officer. I never knew that they had changed my probation. So the guy who came by the house to see me, he just never contacted. I never knew about him.
Okay.
I've always been in contact with Mr. Jerome.
Well, Mr. Jerome, then there may be more than one Mr. Jerome in the mix, but there is a lawyer named Serge Jerome, and he, I think, represented you when, let me find your final disposition here.
Yeah, he represented me some years ago on my probation.
Yeah, so he represented you when you pled, and so have you talked to him since you pled guilty?
No.
Okay, all right. Then Ms. Wood, are you or Ms. Rios in a position to work with Mr. Reid?
I am happy to work with him. I have, Ms. Simpson was very kind to send us what the state and probation's recommendations are. So I'm happy if I could just have like 2 minutes with him. I think we could probably handle this today.
Okay. Mr. Reid, I'm going to put you and Ms. Wood into a breakout room where you two can speak privately. She's going to want to talk to you a little bit about what the allegation is, which, as I mentioned, was just that probation couldn't track you down. You had an officer Foster who needed to work with you, but whatever address she had, which was an apartment on Middleton Road, wasn't working. She left a letter and you didn't report. So talk with Ms. Wood about that, and then you guys will get back in the mix here and we'll figure out what we're going to do. Let me see if I can get you guys in a breakout room. See if this works. So, Ms. Smith, I may need to, is the synagogue case, is that on, I know it's for final plea tomorrow. Are they on the April 23rd trial calendar or are they later?
I think they are,
I can look.
no, they're not.
Okay. So I don't know that I'm gonna have an answer for you by tomorrow. I didn't realize that was my deadline, so that's my bad. So what I may do is just keep them on that trial calendar, but preserve their final plea rights.
Okay. Are they going to be on the May trial calendar?
Yes, they are. That hasn't been published yet, but I have the drafts to review, and they are currently on that May 7th trial calendar.
Judge, we are back and ready to go forward on Mr. Reid.
All right, thank you. Let me get you and all right, Mr. Reid, you back?
Yes.
Good. Let's get on the record, please. These are positions 11 and 12 from our calendar this morning. Both involve Mr. Reid, who is appearing from our county jail. Ms. Wood is representing him. And the petitions and warrants, Mr. Reid, allege that you violated your probation by effectively being unavailable for probation. An officer attempted a field visit at this apartment on Middleton Road. There was no answer. A letter was left with instructions to report. You did not report. And so they haven't been able to keep up with you. You owe a whole lot in restitution, but that's not a reason for you to be stuck in jail. It's the fact that probation could not find you, and it's your job, not theirs, to keep that relationship open, whether it's a new phone number, a new address, or whatever's going on. Ms. Wood, is Mr. Reid admitting to having not kept up connections with probation?
Yes, Judge. So I want to make sure I get this right, and he might have to correct me. So he had a probation officer, Officer Jones. He was working with him. Mr. Reid went through a little bit of a hard time. He was living in a hotel. It sounds like maybe that address was never updated. Officer Jones, he was still in contact with Officer Jones, but Officer Jones, of course, said that I can only visit you at my jurisdictional addresses. And then he was assigned a new probation officer, and he never was officially linked up properly with the new probation officer. He does have a place to stay with his mom in Lithonia. I'm going to get that address to Ms. Simpson after this. He's 38 years old, Judge. He's been in custody 42 days. He has informed me he's got a job with Stone Trucking Group, and he believes that they are holding his job through the end of this week. So he's eager to get back out and in the workforce and hopefully just stabilized. He knows to enroll in the Family Violence Intervention Program by May 1st, as probation's requesting, and to make some sort of restitution payment by then. I'm asking the court to revoke 30 days and reinstate to probation.
All right. Ms. Smith, what is your view as to what should happen?
Yes, Your Honor, in this case, the state will be following probation's recommendation, which is to revoke 2 months and to reinstate the balance with the condition that the defendant under indictment 8151, that he enrolls in the Family Violence Intervention Program by May 1st, and then under that second indictment 2707, that the defendant pays restitution by May 1st. The defendant has been in for about 42 days, so of course credit for the time that he served, with remaining, I believe, 18 days to be served under the revocation, 2 months that we're asking for.
Okay. I get the enroll in the Family Violence Intervention Program. When you say pay restitution, the figure is very large. You're not suggesting that by May 1st, which would be he's out for 2 weeks, he needs to pay $20,000.
No, Judge. He just needs to make a payment.
Got it. Okay. He needs to start making payments. He was making no payments?
That is correct, Judge.
Understood. Okay. And the addition of FVIP is because of something that happened while he was on probation or oversight by the sentencing judge?
Yes, Judge. That was a condition on the original sentencing given on the case ending 151.
Got it. So it was a condition that he had not met.
Yes, Judge.
Understood. Okay. Mr. Reid, did you follow what your lawyer said and what the prosecutor and the probation officer said?
Yes.
Do you have any questions about what was discussed?
No, I actually, I was always in talks with my first probation officer, and then he did lower my monthly payments to 30. This was before I was arrested. I had just spoke with Mr. Jones. I never knew about a warrant or anything. So he did, with me, upon my release, going through different jobs and everything, then moving, I had to move to a hotel. I did sign up for the family violence class, but I didn't know that they was going to be charging every class.
Yeah, it's not cheap.
I was already living in the hotel, and everything was just so much. So I did ask for my probation to lower because they had me paying $100, which I was making payments, and it just got too much for me. So
okay.
I recently changed it to $35 a month for me before I was arrested.
Got it. And you should know that payments are always going to be according to your ability to pay. So if you are in a job that pays you $10,000 a month, you're going to pay more in restitution. If you're in a job that pays you $1,000 a month, you'll pay less in restitution. And as long as you're showing your officer, whether it's Officer Jones or someone else, hey, look, here's my pay stub. I only make $50. All right, then you're going to pay $2 in restitution because you need to eat, you need to pay your rent, all that stuff has to happen. But the payments need to be more than zero once you're working again. And I get it that when you get out, first you got to get a job and get back on your feet.
Right. And,
okay.
Yeah, I don't want to serve any more time. I feel like this was, it's too much time, and I haven't been in any trouble since my release.
I hear you, but also you lost touch with probation, and ultimately that's on you. They went to where they thought you'd be, you weren't there, and so I'm hearing you. Here's what I'm going to do, Mr. Reid. I do find that you violated your probation by becoming scarce so that they couldn't find you, and you have not taken the Family Violence Intervention Program classes. They're not free. You're going to need to figure out how to manage that, but you're going to need to provide proof of enrollment pretty soon to probation. So I am going to revoke 2 months of your probation. You will get credit for all the time you served. You may get 2 for 1 credit. So you may be done. The sheriff will figure that out. I'm going to require that you provide proof of enrollment in the Family Violence Intervention Program by May 15th. Let me make sure that's a weekday. By May, yes, 15th, that's a Friday, that you provide proof of enrollment. And like, this is the class I'm going to go to, or I've been to one, I'm underway. And by May 15th, you will make some contribution to restitution, whether that's a nickel or $5 or $500. You're just going to get back in that process of paying a little bit as you are able. And then you and your new probation officer, you're going to have a new one, because if you're living out in Lithonia, it's going to be a different probation officer. You and that probation officer can figure out what's a reasonable payment program. But we are going to need to get that address in Lithonia, so you can get reporting instructions as to where you will plug back in with probation.
We still have his case until Ms. Wood gives me his address. Mr. Reid, your current officer's name is Officer Spotwood. Officer Spotwood.
Spotwood, like a piece of wood with spots on it.
Okay, Spotwood, okay.
So that is who you need to see as soon as you get out.
And does he go to the Fulton office to try to engage with Officer Spotwood? How does he track Officer Spotwood down?
Yes, Judge, he needs to come to our office within 48 hours once he is released, because we have his case until his transfer is actually completed.
Got it. But let's say, I'm making it up, he gets released on a Thursday, and on a Friday he goes to the probation office. What's to say that Officer Spotwood is going to be at the office as opposed to out in the field?
Then they will give him a new reporting date, but he
Okay.
needs to still come in so that they can notate that he did report.
Got it. So, Mr. Reid, you're going to get out soon, and when you do, you're going to want to reconnect with your family and whatnot, but you will also, within 48 hours of being released, need to get back to the probation office here in Fulton County. Do you know where that is?
Yes.
Where is it?
I believe that's on Memorial Drive.
It is on Memorial Drive, and you need to go there within the first 2 days of your release and say, hey, it's me, Mr. Reid. I'd like to see Officer Spotwood. If Officer Spotwood is there, the two of you will connect. If Officer Spotwood's not there, they're going to give you other instructions, but you will get credit for having shown up, which you must do within the first 2 days of your release.
All right.
Any questions about that?
No. How can I find out if I can get awarded for 2 for 1?
You're going to talk with the folks there at the jail. They're the ones who do that magic math, okay?
Okay.
Ms. Wood, anything else?
No, Judge, thank you.
Thank you for filling in. Ms. Smith, anything else in connection with Mr. Reid's 2 cases?
Nothing further, thank you.
All right, good luck, Mr. Reid. Make sure you plug in with probation. I don't want to see you again in 6 months where they say, where is this guy? He's a ghost.
You're really supposed to see me today, Your Honor.
All right, good luck.
Bye.
Bye-bye. And with that, I believe we met with everyone except poor Mr. Estabbon. But we will work with the sheriff and Floyd County on that and get him here. Anything else, Ms. Smith?
No.
Ms. Wood?
No, Judge, thank you.
Judge,
All right.
I have a question before you cancel the Zoom.
I'm here. I'm actually leaving it open because our civil matter, they may need to use it. So I'll just mute things in the courtroom, but it's going to be on hold till then.
Okay, but I need the team on the call.
We're all here. No one's going anywhere.
Okay. Miss Smith asked about evidentiary hearing that's next Tuesday, I think Tuesday, the 7th. It's on April 7th at 1 p.m. It's regarding Cordelius Sanders, 24 SC 001059. I have listed Gabe Banks as he's handling the case, but I don't know if that's true. And I'm just trying to find out if the defendant needs to be transported from DOC or if his hearing can be via Zoom.
He's not in DOC. He is in federal custody.
Okay, that's what I knew. There was something different about him. I think that we need to reset this or something needs to happen, Judge, regarding this. I'm not sure.
Okay, can you give me that case number again? 24 SC.
001059.
And Judge Gay Banks sent out an email on February 20th to the court saying that he does not represent he will not be representing Mr. Sanders in this revocation.
He's done. Okay, let me look at the final disposition.
This, is it Cordarius Sanders?
Yes.
Yes.
I think it looks like he might be in Fulton County Jail.
Yeah, it's got an orange J. Let's look. Jailings. He's got a booking number. And yeah, he's still in.
I did speak with Mr. Woods, that's the AUSA that was over the federal case that he's indicted, and he told me that he was housed at the Robert A. Dayton Detention Facility.
Ah, okay. He's loaned out. I see.
Yeah.
Interesting, because he does have an active booking number. And that Dayton, that's in Lovejoy, so it's not far. We have in the past connected with people there virtually and had them produced. But Mr. Banks is off. He handled the plea, and he's done. Is a 9, so I guess that would be Ms. Rios.
Yeah, I've been talking to her about.
Oh, you have been talking to her. Okay.
Starting today, I've been emailing her about the judiciary hearing next week. So I'm thinking maybe it's her case or she's assigned to that case.
And what is the new set of charges that you'd need to prove up?
There are firearms charges, which is kind of tied in with why he's in federal custody.
So it's just he had a gun. I mean, it's a possession of a firearm.
Your Honor, you guys done with me for today?
Yes, ma'am. Didn't mean to keep you on. Thank you so much.
All right, you guys have a great day.
Bye-bye.
It's possession of marijuana, possession of firearm by convicted felon, possession during, and that's it.
Okay, so drugs and guns, what would be for us a fairly routine case, but somehow the feds grabbed it?
Yes.
Okay. So
Nicole Vaughn used to be in your office, Miss Smith. I don't know if she's still there, but she's the one that does the federal to get people out of federal to be transported to when we have a hearing. But usually she needs like a month.
Thank you.
Yep, it says loaned out to U.S. Marshals. So we need to figure out if they would. I know in the past, Derek Wright managed to get someone on a screen, but it was like in a federal facility in Tennessee. It wasn't Lovejoy.
And it was for a plea too. If this is an evidentiary hearing, that's going to be a lot longer. I don't know if they do those type of hearings. I mean, I can start researching, but
well, I guess another way would be if you want to reach out to the AUSA and say, do you guys ever do anything via Zoom? And he might have a point of contact at Dayton for us to reach out to. But if we need to have Mr. Sanders here, which is fine, that production order is more complicated. And I'm remembering what Ms. Nelson is remembering, which is Ms. Vaughn or whoever her replacement is in your office does some paperwork. And even though Lovejoy is 45 minutes from here, it can take a few weeks to get that ironed out.
So I wish, by the time this case was brought to me by our Chief Joyce, he requested for us to add this case to a calendar. He actually has two cases. One was handled by Judge Whitaker. But by the time he brought it to me, ATF was already in process of scheduling to, I guess, to take over custody.
Is he a YSL guy?
That part I do not know.
I mean, just because he has a fancy lawyer, and the feds are interested, and there's the Judge Whitaker angle. So
Yeah.
I'm curious if he was part of that larger case, and then he had this separate one that we dealt with. Does he have enough probation left that is worth us spending this? Because he only has 3 months left. We're not going to be done with this in time.
Yes, his case, the one he has with us doesn't end until 2039.
Oh, good. We got plenty of time. Then we want to get him. So let's figure out how to do that. Thank you for flagging that, Ms. Nelson. If you would start the process, Ms. Smith, by one, reaching out to the AUSA, but also figuring out if it's Ms. Vaughn, if she's still there, and if it's not, who in the DA's office does the federal production stuff. And I think I need to sign things. I'm happy to help in whatever way, but it was usually Ms. Vaughn would send stuff over and I'd sign in a few places and that would get someone produced.
Okay, got it.
It'll be good for you to learn how to do that anyway, because you will at some point need someone as a witness in one of your cases or whatever. How do we fish people out of federal custody?
So I guess we will remove it from the 7th because I don't believe that Nicole would be able to get the person here by the 7th.
I mean, you've already published a calendar, so let's keep it on there. So that's a reminder for us to look at each other and say who's done what. And if Ms. Smith learns from the AUSA, Lovejoy does Zoom, then we want to hear from Ms. Rios. Is she okay having Mr. Sanders appear via Zoom? But I guess we want to figure out a little bit in advance so you need to subpoena some people. You have already. Okay, so let's just see what we can find out in the next this week. And if by Friday is looking like it can't happen, then you can call off the subpoenas. No one will be wasting their time. But I don't want to call it off until we at least get a few answers about, it'll take 2 weeks or what. And let's keep Ms. Rios on those communications since it sounds like she'll be handling it.
Okay, thank you, Ms. Smith.
No problem.
Ms. Nelson, anything else we can do for you?
No, that's it, Judge.
All right. Thanks, guys.
Thank you. See you tomorrow, Judge.
Bye. I guess someone let the interpreters know they didn't need to come back, which is good. All right, I will mute things in here. We will be down.
How'd the wedding go yesterday?
Yes, hello? Oh no, they put it on a Zoom. But how can I present my evidence on the Zoom? Okay, so basically I could just probably like take pictures of it and send it to them. Right. Well, we're about to be on the Zoom at 12:30. They changed it. Yeah, we're on Zoom at 12:30. Can I still press charges? Okay, thank you. Well, hold on one second.
All right, good afternoon, everyone. This is Judge McBurney. I am here for the damages hearing in Harris versus Barton, which is 25 CV 011259. Mr. Denhart is here. I'm going to add you to the screen. Mr. Barton is here. Add you to the screen. Don't really need to have the courtroom. Mr. Denhart, good afternoon. How are you?
Good, Your Honor. How are you?
I'm well. Thank you for shifting your schedule around a little bit. Mr. Barton, good afternoon.
How you doing, Your Honor? I'm good. How you doing?
I am also good. Thank you for shifting your schedule. I learned in poking around in the docket to get ready for today that really this case should have gone to Judge Farmer, who is the successor to Judge Adams's civil docket. I didn't realize there had been a lawsuit relating to these very same properties. And generally the way we work it here in Fulton is that a related case goes to the judge who handled the earlier case. But that was not brought to my attention, and it would not make sense to transfer this to Judge Farmer now because I learned a whole lot about this. But for future reference, if for whatever reason this case doesn't resolve the endless dispute about 389 Glen and 1465 South Gordon, and you guys sue each other again, you should flag it when you file the lawsuit that it's related to earlier litigation. All right, enough on that. We are going to talk about damages today. And so, Mr. Denhart, I'm going to start with you. And then, Mr. Barton, I promise I will hear from you as well. This involves two pieces of property. I gave the addresses just a moment ago that are or were owned by, I'm going to probably mispronounce it, Dum Vivi, which is an LLC that Ms. Harris contends she started. And she needed to refinance these two properties, but she had had some legal difficulties in the past, a wire fraud conviction. And so she brought Mr. Barton in to help by being someone who could refinance and didn't have a federal criminal history, but that all of the money side of things flowed from Ms. Harris. And then when Ms. Harris and Mr. Barton's relationship soured, she said, hey, you need to give me these properties back. And Mr. Barton sold Glen Street and was trying to sell South Gordon when lis pendens got put in place. And what Ms. Harris is trying to do is claw back the amount she invested in both properties. If Glen was sold, Mr. Barton got some money for that, and Ms. Harris is claiming that some of that ought to go to her. And if South Gordon remains stuck, then we need to work through how we unstick it so that if the goal is to sell it, it can be sold and money is allocated as it ought to be between Mr. Barton and Ms. Harris. So I'm sure I missed some of the finer details, Mr. Denhart, but you are going first, so you should clear up what you think I'm misunderstanding and then present what evidence you have as to damages. And then, as promised, I will turn to Mr. Barton and he'll have an opportunity to present what he wants to.
I think that was a wonderful recap, Your Honor. I have two exhibits. I emailed them. I don't know if you want me to screen share them or however else you might want to receive them. But Exhibit A is a limited warranty deed showing the sale, and Exhibit B is an associated PT 61 form showing that the sales price was $510,000.
Okay, let me look for I guess the easiest would be if you want to screen share it. That way we're all looking at the same document and we're not running, wait, my copy doesn't say this or say that. So if you want to put Exhibit A up, that's great.
Is this coming through for you, Your Honor?
It is now. Yep, it took a second, but it's there.
and this is Exhibit B.
B is what?
Can you say that again, Your Honor?
I don't know what B is. It's a little small, so I can't read it. I'm just curious what it
I
is.
can. Oh, sorry. This is a PT-61 form showing this is for the associated transfer that the property was sold for $510,000. The property that was sold prior to litigation.
Got it. So this would be the Glen Street property.
Correct, Your Honor.
Okay. Is it called a PT-61? All right.
It is a tax form associated with the sale, Your Honor.
All right. And there's the 510. Okay.
And we are also seeking an equitable order for the return assignment of dumb VV. We can email you an assignment form if that makes it easier for you, Your Honor.
So what that would do, if granted, I don't know if return is the right word. Was Dumvivi originally something that Ms. Harris controlled? Because Mr. Barton has pointed to the fact that if you look at Secretary of State, Dumvivi appears to be his LLC. So you're going to have to remind me of its origin story. And then I'll ask my question about what would this equitable order do?
The original complaint states that Harris began DumVV LLC, and the transfer for refinance was of DumVV LLC to Mr. Barton. The refinance was done, and instead of transferring the assignment of the LLC back to Harris, one of the properties was sold, and the rest of the corporation has still not been assigned back to Harris.
And in transferring Dumvivi to Mr. Barton, Ms. Harris was necessarily transferring the two properties because they were the property of Dumvivi.
Correct, Your Honor, and they're also the only assets of DumVV. Okay. There are no other assets associated with the corporation.
Got it. Equals the two parcels. And so now I'm caught up. So while Dumvivi was Mr. Barton's LLC, he sold Glen, and that's the 510. South Gordon the sale has been halted because of the lis pendens in place. And the equitable relief you're seeking is effectively the return of South Gordon. But really the way you do that is it's returning Dumvivi to Ms. Harris.
Correct, Your Honor. We're not transferring the properties independently. It's the interest in the corporation that holds these two properties.
Got it. Well, holds one of the properties. So the order would have the effect of changing the ownership of Dumvivi from Mr. Barton to Ms. Harris.
Correct, Your Honor.
Okay. Now you showed me that Glenn sold for 510. Does there need to be any, I don't remember what was alleged specifically in the complaint, and this may be what Mr. Barton's going to share, but if Mr. Barton invested $100,000 into it, then it's not a judgment for $510,000. There would be some offset, and it may be that, I don't know if there was a mortgage on the property or what. It sold for 510, but we don't know what the net was.
That's correct, Your Honor. I only know that it was 510. I have no idea how much was put into the property or what the mortgage was for on the properties.
Okay, so then what is the relief that you're seeking on the financial side?
It would be 510 minus whatever Mr. Barton would show as either paid off in a mortgage or that he independently spent on the property. I have no access to that information or those numbers.
Got it. So the default, absent any showing by Mr. Barton, would be a judgment in Ms. Harris's favor of $510,000, because we know that's what Glenn sold for, and then this equitable piece of returning Dumvivi to her.
Correct, Your Honor.
All right. Anything else you want to share at this time? I'll come back to you after Mr. Barton presents what he is going to. Anything else at this point, Mr. Denhart?
Nothing else, Your Honor.
Okay. Then let me pivot to you, Mr. Barton, and I am ready to receive from you whatever evidence you want to share.
Well,
and when I say share, if you're going to be relying on a document, either that's something you need to email so Mr. Denhart can see it, or pop it up on the screen, whatever, however you want to work that.
Okay. So basically, Your Honor, get my glasses. While liability has been established by default, the plaintiff still bears the burden of proving damages were competent. Non-speculative evidence, defendants demand strict proof of alleged damages.
I hear you.
And I need to see by, everything that I need to see. We need to see receipts. We need to see documents showing her name in the business that she claimed allegedly that she started, which she didn't. I'm an investor, and this is what I do. This young lady has a record. We had, I guess, somewhat of a relationship, and she didn't do anything. She didn't start this company. She did not put any work into anything. The only thing that she was good from now that I know her, because I didn't know about her past before, is she was just good with paperwork, as far as what I'm understanding about her now, because of her past record. She was helping me basically with my investment, and that was just the paperwork. She wanted to do business in the sense of not business, excuse me, that's the wrong term, not business, but she wanted to get her name wasn't good. I didn't know these things going into the relationship that we had, because I never took it upon myself to actually look at her record, Your Honor, and see what type of fraud or mortgage fraud that she was, had been accused of. Me coming, trying to give her a chance to reestablish her name, resulted into her claiming allegedly that she started this company, that she got this property, she brought this property, when in fact I put everything on the record for you, as far as the deed, the mortgage, everything that's on record that you see, as far as me showing proof that I am the true owner of this business. And like I said, she assisted me. And because she was good at what she does, now she's claiming that she owns these properties. And
so what we've got, Mr. Barton, I'm going to let you keep going, but we don't get to relitigate certain parts of this, because I found that you were in default. The allegations that are set forth in the complaint that Ms. Harris filed are the evidence in this case. And it is alleged, and now is deemed to be the facts of this case, that in September of 2016, Ms. Harris created Dumvivi by filing articles of incorporation or organization with the Secretary of State. She paid the fees, et cetera, and moved on. So we're not relitigating that part. The record for this case is that Ms. Harris created Dumvivi, transferred it to you because you could get credit and she couldn't. She had a bad name, whatever phrase you use, but I get it, that she had some criminal issues that make her not a great candidate for lending and whatnot. And so you did what you did, and now we're in this situation where Glen Street was sold, and Ms. Harris didn't get anything for Glen Street. So what you can share with me now is what you put into the Glen Street property, because if you've got evidence that you paid a mortgage, you rehabbed it, refurbed it, whatever, and you've got receipts, not someone else, then those are offsets that would go against the amount that under this complaint, which stands admitted by way of the default, the amount that Ms. Harris is owed for the sale of the Glen property. Does that make sense? I'm not asking if you like it. I know you don't like it. But I want to make sure you're following what I think.
I don't know what you mean by when you say that she transferred anything to me.
Well, I wasn't there when you all did what you did, let me keep going through the complaint, because that's the record for this case now.
I mean, I'm asking upon what actual evidence does Mr. Hart have to present it, showing that? Where is showing operational agreement or anything of that nature, and transferring my company to her? Like I said, we're not going to talk about the personal part, but I just
Right. So here's the record in front of me, and Mr. Denhart doesn't need to prove any of it. It was alleged, and as I said, it stands admitted now because of the default judgment. And let's find the Glen Street one, because that's easier. October 2016, We Buy Now Atlanta, Ms. Harris's real estate company, purchased Glen Street for $30,000 from Franklin Charlene. And she negotiated with the bank, got a big old mortgage balance removed, et cetera. And you were not involved in the original purchase of Glen Street. That is paragraph 17 from the complaint. Those are the facts of this case. Mr. Denhart doesn't need to prove anything in connection with that. So we are back to what I just described, which is if you have evidence that shows that you put money into Glen Street such that some of that $510,000 ought to go to you, this is the time for you to share that with me. It's not the time for you to say, hey, Denhart, prove that Harris did X, prove that Harris did Y. He proved it by the default that was entered. And so we're done with those discussions. It's what as I said, is the record of this case.
Okay. So basically, if you go to, well, I mean, I don't know how I would give this to you, but we would have to go back to the banks and show how I pay for the mortgages through Lehman One Capital, showing all the payments, which I do have a record of all those payments of me putting in the monies for the mortgage. And I have different receipts as far as me managing the property, me managing all the properties,
When you say all the properties, we're limiting that to Glen Street and South Gordon Street.
This is very complicated because in the sense of that, we was working together. Okay, like I said, she was assisting me as an investor.
Okay.
Okay. And the thing about it, she was doing the damages of all the, if we go back to the purchase of even 389 Glen Street, I can clearly show where she was doing damages to the property because I had gave her a certain amount of control. And that control was to maintain the properties while we had them under Section 8. It was my idea to do the Section 8. It was my idea to make these for low income housing for the community, and I have all that on record. I have everything.
When you say properties, though, I want to make sure we're talking about the same universe.
Well, the reason why I said because that's on the collateral loan that I have with Lima One Capital that's in my name. Now I have the loan on these properties. Both of these properties was a collateral loan to Lima One, and it clearly shows that I am the guarantor of the mortgage. I am the one that is paying on this loan that she did not help me pay on to bring it back up to bring it. Actually, she damaged it because we want to go into the whole criminal case with her also fraudulently trying to transfer WVB back to her by using my name, and I put that also on record. Okay. And then at the same time, that wasn't even no one stood on that, because if you look at the last case before you, Judge, I'm sorry, I forgot the judge's name, he dismissed it because she couldn't prove anything, and 389 Glen Street was sold. And like I said, these are two properties that were on a loan together.
Okay.
So I am responsible for the loan. I'm responsible. I have the taxes. I paid the taxes on these properties. I pay all the mortgage on these properties. I paid for the roofs, the maintenance, everything. Like I said.
Okay. And all of that is something you can prove today. That's not something something to the contrary was alleged in the complaint. So now's the time to not just say it, but so show me the tax bills that you paid, or the mortgage you've been paying, because we need to we need to create that record.
Well, that was the whole thing about when you guys had called me earlier about how this is supposed, because I asked the young lady, I said, well, how am I supposed to, because I'm not good at this as far as putting these things, zooming and showing all these different things. I can show you the documents. I'll have to try to show them to you the best way that I can.
And Mr. Barton, I am comfortable if what we need to do is give you an opportunity to make copies of these records or scan them, as well as summarize them. And what would be helpful for me, and I think Mr. Denhart, would be if you were to say, hey, I'm making the number up, $62,000 in mortgage payments before Glen Street was sold. That's your summary number. And you back it up with copies of all of the mortgage statements. And if you've got that, you could scan it.
I'm sorry, go ahead.
You could scan it, and I'm happy to say, we're going to finish our discussion today. This is when it was scheduled. It's been scheduled for a while. But to give you a window of time in which to submit to Mr. Denhart and to me these documents, and then Mr. Denhart will have a chance if he's got questions or concerns. If we need to reconvene as a hearing, we can do it. He may say, look, that's a legit bank statement, and Mr. Barton paid $62,000 in mortgage payments on Glen from the time it was transferred to him.
Sorry, I paid way more than $62,000.
I'm making the number up. The number is whatever the number is. Right now, that number is zero because you haven't provided any evidence of it. But I want to give you that opportunity, and I recognize that you are representing yourself. You don't have a lawyer in the mix. Today was the day to have that ready. Even if you had come into court, it wouldn't have worked for you to just wave a bunch of documents around. I need what the totals are. You could say, I paid a lot of interest, and you point at a stack of documents. But for Mr. Denhart to be...
I was going to point at a bunch of documents I have to load up in, Lima One Capital portal, but like I said, I didn't know how I had to present those documents to you on the Zoom, because first we didn't even know how we were going to do this today, because I was prepared to come down there and show everything that I had. Like I said, I'm not used to this. So I have all the paperwork of me paying all the mortgage.
Okay.
From top to bottom. I have all the receipts through Lima Porter Capital, through Lima One. They can show you. I have I have insurance, it's my name from Lima One. I have gas bills. I have the light bills, So I have all these different documents. I know you can't see them.
Right.
Okay, and I have all, there's a $23,000 water bill that she was negligent on because she mishandled the monies. Okay. She did not. There was a time where even on the Section 8, she was in control of some of the monies, and when I found out was that she was not upholding the policy for the Section 8 because, like I said, we're working together. She had a certain thing we were doing, but there was no operational agreement between me and her because we were in a relationship. She was helping me. Okay, as me as an investor, my name is on the mortgage. My name is on the deed. Okay, I've been paying all the bills for both of these properties.
Okay. Well, then tell me.
I'm sorry. Go ahead, Yana.
Tell me how much time you need to compile the records you've been describing in a way where you've scanned them in so they can be delivered to Mr. Denhart and to me. And you've included a summary sheet that says, all right, Lima 1 mortgage, I paid $112,000 for Glen Street mortgage before I sold it. And then you've got all the pieces of paper that back that up so that Mr. Denhart can look at it and he can turn to his client and say, yeah, look at that. He paid $112,000 in mortgage, whatever it is. And if he thinks that the documents don't support that and we need to reconvene this hearing, we can do that. But I need to know how much time you need to do that. If you had just come into court today and waved it around, it still wouldn't have worked.
Right. What you mean wave what around? The actual statements? Bank
Right. I
statements?
mean, I don't know what you thought was going to, well, it doesn't matter. Tell me how long you need to get these documents organized and scanned.
Yana, I'm asking you, what do you mean by that when you say when I'm saying I have the payments sheets? The payments went in Lima One Capital showing me making the payments through my bank.
Right.
But from the beginning.
Okay.
Cool. Is that I mean, I could have showed you that if I came to court today. I could have showed
Your Honor,
you.
Hold on one second, Mr. Barton. Yes, Mr. Denhart.
Your Honor, if Mr. Barton wishes to testify to an approximated number that he has ready, I'd be willing to accept that in order to move this case forward and not have another ongoing hearing.
Okay.
Okay, so here's the thing. There's $187,000 left on 1465 South Gordon.
So let's not talk about South Gordon first. Let's talk about Glen first.
It's on the same, it's a collateral loan, Your Honor. It's on the same, it was the same, one payment went to both.
It's one loan for both properties.
One
Both
loan.
collateral for one loan.
Okay.
Your Honor.
All right.
And I can show all, however you want, I can come down there. I can show you all those statements, all those bank statements, me showing me consistently paying these mortgages because like I said, it's a collateral loan. I am on the mortgage. My name
So
is
how much have you paid on the mortgage since you were responsible for it?
I mean, most whatever it was due in the loan from the time of beginning.
Well, you said you've got this payment sheet that shows the payments you made to First Lima. What does it add up to?
I mean, I haven't tallied it all the way up, Your Honor, but I mean, I have to show you the whole thing for both of them because like I said, this is complex. It was two properties. So I have to backtrack also with Lima to get also some of those statements as well.
If you had shown up in court today, if we had in-person court instead of virtual, what pieces of paper would you have shown me that demonstrate, that prove, here's how much Mr. Barton has paid on the mortgage loans associated with the properties?
Well, it showed you from the time of 2016, I would have showed you all those payments and from my bank.
Okay. And you have those with you right now?
Yes, I have those and I can bring those to you.
And what do they add up to?
In fact, can I just look? I gotta go to.
Please feel free to look. I appreciate Mr. Denhart trying to streamline it. If we can sort it out today, we will. I don't know that we'll need a second hearing, Mr. Denhart, if Mr. Barton is able to get you some of this paperwork and get me some of the paperwork, but
I can get Denhart some of the paperwork. I mean, that's no problem. But like I said, I have to tally up like both of all the properties. I have to go back and get all the payments from that time from those two. So I'm pulling it up now, but I have to, like I said, I'm pulling it, I'm downloading as we're talking right now. And
Was
then,
it the same amount each month that you paid?
yeah, it was 2400. I have the matter of fact, I have the document right here.
Excuse me, Judge Robert, this is Gia Harris here. Can you give me permission to talk if that's possible? I don't know.
Nope, you go through your lawyer. Your lawyer is your spokesperson, and if he doesn't want you to be talking right now, you need to follow his advice.
Okay, thank you.
Sure.
My thing, Your Honor, when the first property was sold for $389 and she couldn't prove it then, and then there was a fraudulent, her forging my name, why wasn't this stopped then?
So I didn't handle that case. We've got this case, and as I've told you, because you defaulted, the facts that I have, the record that I have is that the properties were purchased by We Buy It Now, which was Ms. Harris's company. She folded them into the Dumvivi LLC. She transferred that LLC to you. You did what you've done. You're being given an opportunity now to show me what you paid and invested in those properties during that window. And then when Ms. Harris said, hey, you need to give this stuff back to me, instead of saying, sure, you sold 389 Glen Street, gave her $0, and you tried to sell South Gordon, but that was blocked. And don't respond to what I'm saying. I'm just telling you, this is where we are. So I don't know how that other case played out. It wasn't my case. You all didn't bring it to my attention. And so that ruling doesn't control what happens in this case. Separate lawsuit. And in this lawsuit, because of the default, the record is that Dumvivi is Ms. Harris's LLC. The only assets of Dumvivi were the two properties, which she purchased through We Buy It Now. She transferred that LLC to you because she's got credit history issues. When she asked for it back, you didn't send it back, and you sold Glen Street. I think we all agree Glen Street was sold for $510, and Mr. Denhart, I think, is being very reasonable and saying, look, just show us what you invested in, paid for, did in connection with Glen, and that gets backed out of the 510.
No problem. I will show you all the mortgage payments.
Okay.
All the mortgage payments. So how do you want me to do? I need to come down there and just get it printed out and send it to you? How do you want me to send it, sir?
Well, I was trying to sort it out this way. You said that the monthly payment was $2,400?
Yes, sir. Excuse me 1 second. There it is right here.
So holding it up is not going to work because the camera doesn't focus on it. And Mr. Denhart wanted you to just give us a sense. What did you pay?
$22.92 a month. What the interest rate was at 8.7, but it's $24.92 a month. Okay.
And that was the same number every month as long as you were paying.
As long as I was paying.
And are you still paying because you still own South Gordon?
I'm still paying on the mortgage. She hasn't put nothing to nothing. I'm still paying on these. I'm still paying on the loan, sir.
Okay, and the loan was secured by both properties, so it's still there. It's now secured by only one property because Glen was sold. And you're saying you're still paying $24.92 every month.
I'm still paying $24.92 every month.
Okay.
And I've been paying it. And only thing, like I said, she may have helped with certain things, but she didn't take responsibility for this loan. She didn't take no responsibility for this loan. I mean, okay, start up a company and this and this and this and that. Okay, but that's irrelevant. She didn't take no responsibility for these loans. She hid herself behind this, you know what I'm saying? And I'm paying out the pocket. She didn't try to resolve anything with the debts. I even have credit cards and fraudulent things that she put in my name. I have a whole bunch of other stuff, but like I said, it's no here or there. We're going to stick to the payment things.
Right.
But I understand of like, you know, there was already a criminal act already, you know what I'm saying, that was involved in this. And it's like, how did it even get to this? Because if that was the case, 389 Glen Street, I wouldn't been able to sell it. If that was.
Well, you're straying from where we need to be, which
I
is
understand that, but I'm just saying. But now I just don't understand how the justice system can allow her to do that. Okay, because she clearly quick deeded herself to it, so she didn't have no ownership of the property. Anybody could transfer a property and do what they want to do, but that doesn't mean they have ownership of they're operating that property, because you have to have money behind that property. You have to have equity behind that property. Someone has to been able to be responsible for the payments of that loan. And Ms. Gia Harris was not responsible for the payment. She was a face. And that was it. She was not responsible for anything, for all these things that I had, and I've been having the burden of trying to catch up on certain things. And what they're asking for is as far as what she thinks she's owed, even when helping me, damages with contractual work, which I'm finding out things that she didn't pay now because she also had control of my bank account and in a situation. So that house did not sell as she think that it did, because she got certain people to do certain things, and they were all criminals because they had half work being done. The foundations was broken apart. Nothing was Section 8 was up to par. I had to keep when this went sour, I had to be the one to keep everything up, because she just wanted to get some money. She didn't care for the whole aim was for this investment, you know, for us to make money when we was together, you know, but we don't have no operational agreement as no company, do no business. That's what I'm trying to tell you. This is not, we didn't do no business. This was my girl. Okay. So she's not, no, so it's not now, okay, her name wasn't good. I get that. And she told me this and this and that, and I understood all that. So I put myself on the line. I'll take care of the mortgage. I'll do this. I'll put the things that because your name is bad, because she couldn't do real estate no more. But I'm trying to create a family at this point. You see, it was an operational agreement. It was me, you know, listening to my girl saying, okay, I get it. I understand. I never looked into her criminal record at all. Okay. But I took it upon myself to put the mortgage, you know what I'm saying, and everything. The mortgage is my name. Do all the payments, anything that's related to these properties. If it falls, it's all on me. She can walk away scot-free, and that was the whole reason why you look at it right point in there, put her name on anything. Didn't matter. Anybody could transfer a company. That doesn't mean that they're operating the company. That doesn't mean that they have the merit or showing anything that keeping it up. You got to keep these things up. You got to maintain these investments. You know what I'm saying? She defaulted on these investments. She defaulted on the house. If you even look at the home insurance, she didn't put insurance on the home. I had allowed her to do certain things in my, you know what I'm saying, with my name, okay, as a couple. And she defaulted on all of that, you know, bad contract work, because she knew people. She knew people, but she knew how to do things at, you know, beating people out of money to do things. I almost got them near shot because contractors are asking for monies because they're saying that she owes them this and this and this and that. So it's a lot of things I didn't even know about Ms. Harris and her fraudulent ways of her doing business. She didn't do things on the up and up. She was not honest, and she wasn't transparent with anything she did. She put me in this situation. Okay, she may have had this company, but at the same time and transfer. Okay, I get all of that, but she didn't operate the company. She's not on any operational agreement. There is nothing showing that she has any capacity to make any decisions about any monies and where they need to go. And I need to figure out why that's not being stood on. Because we can go all day and I can give you these documents and all these policies and these taxes, and I have all this stuff. She's not paying the taxes on the property. She didn't pay the back taxes on the property. She didn't pay for the mortgage. She didn't pay for the program on the AAH Section 8. I took all that. I put all that's me. And I'm still paying on these things. I want her lawyer to show me where she's in any operational agreement showing that she was managing, and the monies that she's claiming that she wants for herself. Where? Show me how can you claim that you want these monies when you didn't keep up anything with me with these properties when it was in my name, and these mortgages and the roof damages and the plumbing and all these different things just went to crap because she didn't have the intent to do right by this investment with me. Whether she had whatever. So when I came in, and when we got together, she told me everything about her situation. I believed her. But when I come to find out, she's been doing these things. That's why I said it didn't matter. Like, how could I keep going on? How could this even go on when she fraudulently took my name and tried to quick claim the deed to her as her company? It doesn't matter if you transfer, like I said, a company. If you transfer a company and I'm the owner of the company now, I'm running it now. You may have anybody can come up with a name. Anybody can make a company, a LLC. Doesn't mean that they're running it. And then at the same time, if whatever is transferred, she's talking about, where is, I need to see the proof of that, and then I need to see where, she was any operational agreement between me and her of how these monies need to be dispersed between me and her doing business. Because
I'm going to stop you because you're now getting to hey, she needs to prove something, and that's not where we are in the process. I do have a question for you, Mr. Denhart. If I were to grant the equitable relief and Dumvivi reverts back to Ms. Harris, if this loan we're hearing a lot about is in, I don't know if it's in Dumvivi's name or if it is in Mr. Barton's name, Mr. Barton's been paying it, I would want to ensure that if everything reverts back to Ms. Harris, Mr. Barton has no obligation to pay anything. And equally important, if Ms. Harris decided to default or did default on the loan, that doesn't hurt Mr. Barton's credit. So I don't know if the loan is in Dumvivi's name or what.
It is in Dumvivi's name, Your Honor.
It is in Dumvivi's name.
And if we're taking the testimony of Mr. Barton, presuming that the payment is $2,492, that's around $30,000 a year for 7 years since the beginning of the loan. That would be $210,000. If you would want to knock that off of the 510, leaving a $300 in money judgment.
Okay, well, I'll get to that in a second, but you've helped clear up. So Mr. Barton wouldn't be left holding some payment obligations if Dumvivi reverts back to Ms. Harris because
Correct, Your Honor.
all the loan, et cetera, it's all in the LLC's name.
Correct, Your Honor. It's all in the LLC's name.
Okay, got it. So here's where we are, Mr. Barton.
The loan is in my name. It's not in the LLC's name. The loan is in my name. The loan is in my name. The mortgage is in my name.
Well, that would be a problem. I mean, that's why I'm asking. What made you think, Mr. Denhart, that the loan was in Dumvivi's name?
The security deed says the corporation's name, Your Honor.
Okay.
Says my name.
Well, your name might be on some of the paperwork because you have been paying it, but I guess we'll need to get to the bottom of it because I don't intend to issue any ruling that would lead. If you don't have the property, Mr. Barton, you don't need to be paying anything for the property. That's certainly how this should play out.
Where's the ownership? Where is the ownership of her having ownership of this company?
So we're not going to work through that right now. I've told you about that a couple times. And I want to give you an opportunity here to select how we go forward. Mr. Denhart did some quick math, which I appreciate. Said, look, round numbers, $210,000 for the mortgage payments that you've been making. Now that's mortgage only, but I think he rounded up. It doesn't include taxes, insurance, and whatnot. And so he is willing, without you having to prove anything other than your unsworn statement that you've been paying and it's $24.92 to knock $210 out of the sales price for Glenn. You can roll with that and say that's simple and round and I'll take it. Or You need to tell me how much time you need, and the answer is 2 weeks or less. You could ask for less time to get to me and to Mr. Denhart actual paperwork with a summary that shows here's what I paid in the mortgage, here's what I paid for insurance, here's what I paid for taxes, and if you made any improvements, the actual invoices, not you writing down, hey, the roof was expensive, but here's the invoice and here's proof of payment of the invoice. So it's actual paperwork, and that's all to document money you put in on the Glenn side of things. And I appreciate the mortgage is actually for both, but that's okay. It's going to all go towards that amount. But you need to provide that actual documents with a summary sheet so that I don't have to go through and touch each insurance bill and say, okay, what does this add up to? You add it up. You get it to Mr. Denhart so he can fly spec it and say, you know what, that's close enough. We don't challenge it. And then we're done. We've done the math. More accurately, you've done the math, which is what you were supposed to do for today's hearing. And we'll use that number instead. So Mr. Denhart has said, quick and dirty, let's be done with it. 210 for the mortgage payments, back that out, no contest. If you think that there is more to it than that and want to use your time and energy to get in a easy to access and summarized format to Mr. Denhart and me, additional expenditures you've made in connection with Glenn, such that that ought to be decremented against the 510 as well. I'm willing to give you that opportunity. And then you need to get that to.
I'm sorry, y'all. We're just talking about Glen Street, right?
Correct. Right now, South Gordon hasn't sold. You might want to make a record of that, because if South Gordon reverts to Ms. Harris and she sells it for $500,000, it's obviously subject to the mortgage that's on there. But if you believe that you have invested in South Gordon, and investment would mean you pay the taxes, you pay the insurance, that's all money you need to get back. You're entitled to that. So it's both properties. But you need to identify which is for which. And again, I get it, the loan is across both, but taxes won't be for both. There'll be a property tax bill for South Gordon, there'll be a property tax bill for Glenn. And if you can compile that in an organized way, such that it's easy to figure out when you say, hey, the taxes were $10,000, we can see here are the 2 tax bills that support that figure. Then I'm willing to consider that as your evidentiary submission as to the amounts you would be owed in connection with the Glenn sale and the amounts you would be owed in connection with a future South Gordon sale.
I just feel that plaintiff, she just still has not showed no proven evidence of damages, of certainty. I don't see anything that proves, and this is all speculative. This is nothing. There's what damages.
Okay, I'm hearing those words. You said it at the beginning, you're saying it again. I hear you. And the burden of proof is not on the plaintiff in connection with a default judgment beyond the basics. And Mr. Denhart did that, which was to show what the sale price was for Glen Street. And then that shifts the burden over to you to say, well, wait, she doesn't get 510 free and clear. That number should be reduced by all the amounts you can document you spent in connection with Glen. If I grant her the equitable relief of returning Dumvivi to her, then Ms. Harris will be in a position to sell South Gordon. If she does, that's going to sell for, I'm making a number up, $500,000. You might be entitled to some of that $500,000 because of all the things you've already told me about. Taxes you paid, insurance you paid, mortgage you paid, and other things. If you want to corral that information and present it to me and to Mr. Denhart, I'm happy to look it over and give Mr. Denhart an opportunity to say, you know what, we don't challenge, those all are legit documents and the numbers add up. We don't challenge it. If he does, we can get you here in person. We can do another Zoom. But what we're not going to do anymore today is the carousel of, well, she didn't prove this, she didn't prove that. We are past that because of the default.
That's fine. That's fine, Your Honor. And I also want to just say before I get out of here, this is the thing about the fraudulent, the forgery and these different things that need to be addressed, and how my credit has been damaged by her because of the fraudulent acts that she did, putting things in my name, credit cards. There's more to this. These are the things that would help put the equity into the houses. All these things went into default. So because all and then there were certain things that were in my name that I didn't sign for American. I have documents of American Express cards that were.
So, Mr. Barton, the things you're describing may well be the basis for criminal charges, and you should talk to law enforcement. So hold on. So you could talk to law enforcement. That's not me. I can't press charges against someone. They may be the basis for a civil lawsuit. It may be that you choose to sue Ms. Harris for fraud and for other things. She sued you. She sued you. You're in default. And so that's why we're having this conversation. I don't want to minimize in any way what you've been through. You may be 110% correct with all the allegations that you've leveled against Ms. Harris. This conversation isn't the forum in which we resolve that. Because I've heard you say several times now, wait, where's justice? Why isn't this happening? Justice comes to those who open the right doors. This isn't the right door for that. You didn't sue Ms. Harris. You didn't go to the South Fulton Police or East Point or wherever it would be where you think these crimes have occurred. And if you think that's the right way forward, by all means, you should do that. But what we're dealing with is the relatively narrow universe of the complaint she filed, which said she bought the properties through We Buy It Now, paid a whole lot for them, did some things, made them the sole assets of Dumvivi, transferred that to you for you to do some things, and you never transferred it back. That lawsuit is almost over. The only piece remaining is, should you choose to do it, is for you to present evidence in mitigation as to why you should actually get some of the money from the sale from Glenn and some of the future money from the sale of South Gordon. These other things about Amexes in your name that she signed, if true, would be you suing her or you going to law enforcement. It doesn't shake out in this case.
Okay, what you mean doesn't shake out is very relevant to what she has done as far as like putting things in my name and other properties in my name. I have 5 documents of settlements of properties that don't even have nothing to do with these properties that she forged my name into that I never got paid up of a dime of.
Right, and that has nothing to do with this case, which deals only with South Gordon and Glen Street. You have the full perspective of the tumultuous and ultimately unsuccessful relationship between Gia Harris and Ronald Barton. You guys had that, it didn't go well, and you are pulling things from other parts of your relationship and trying to put them in this box. This box's label is Glen Street and South Gordon. It's not Amex, it's not property number 4, it's not.
All these credit cards.
I'm going to enter an order.
I understand that, but what I'm saying is,
Mr. Barton, I'm going to enter an order that gives you 2 weeks to submit what you think is sufficient documentation that shows money you spent in connection with and only in connection with Glen Street and South Gordon. You meet that deadline, fantastic. You miss it, you've missed deadlines in this case before. There'll be consequences. If you share nothing with me, then the outcome of this is going to be a money judgment for Ms. Harris for the $510,000, the sale price of the Glen property, and the equitable order that returns Dumvivi with its sole remaining asset, South Gordon Street, to Ms. Harris. That'll be what happens if you do nothing. If you want to submit actual copies, not something you wrote on a piece of notepaper, actual copies of your tax bills, of the mortgage statements, et cetera, showing here's what you paid, and then summarize it. Don't just send in 200 pieces of paper, but you summarize it. Here's the total for the mortgage payments. Here's the total for insurance. And you get that to me and you get that to Mr. Denhart by the deadline I'm going to set. I will consider that evidence. I'll give Mr. Denhart a chance to respond. But assuming the paper is what you say it is, he'll say, those are the numbers. No one's trying to take more than they're entitled to. And if it adds up to $400,000, that's the amount that gets backed out of the judgment. But we're not going to talk anymore about how this relationship didn't go well for you. You could decide, if you're a savvy investor, to invest a little bit in a lawyer and have that lawyer decide the best way to pursue things against Ms. Harris. But you have decided not to do that. And you find yourself once again frustrated that things haven't worked out the way you think they ought to work out. I'm just going to flag those data points for you. But you're the savvy investor, and you'll decide if you want to invest some of your money in getting a lawyer to help you out. Mr. Denhart, anything else on behalf of Ms. Harris?
Nothing from me, Your Honor. Thank you.
Okay, I appreciate your patience. Mr. Barton, I appreciate your flexibility in zooming in at 12:30 instead of being here at 1. I will get this order entered later today that has a description and a deadline, and we will go from there. Anything else, Mr. Denhart?
Nothing from me, Your Honor. Thank you.
Mr. Barton, anything else from you?
Yeah, only thing I said is this is going to become a criminal case. I'm sorry. She's been forging, using my name for things I don't know about, and this is the reason why this came to this as well. So that's all I have to say.
Okay. Well, thank you, sir. I'll get this order out soon, and